Greetings, 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 greetings. This is I, your king, King Clifford Jefferson, Senator Godfrey, the fifth Caravan Jew, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, or the King of Peace, which we know in our school of thought as Jesus Christ. Okay? I'm here again on behalf of the heirs, successors, all those who had an intel state left for them. I am now uh, he who was able to redeem that lost estate through what we call is cheating. It cheats back to the crown as a result of the feudal kingdoms being abolished. A lot of you don't have an understanding of what this is all about. So this lecture or this lesson is going to clear that up for you with some concrete, validated information sources so that you can research for yourself. So anybody else who's so-called making a claim in regards to substantiating your right to be here on any land, all right, not just the European continent, not just the Asian continent, not just the African continent, but anywhere on the world. If you have any type of protection in law by a government, then you must be a part of the social order, i.e., that body of politics. The body of politics is when you, as the sovereign, give up some of your sovereignty in regards to the representatives who now become the sovereign. And sovereign comes in two forms, which a lot of you misunderstand. All right? Sovereignty comes in two forms. No one is sovereign to themselves. Okay? No one is sovereign to themselves. Sovereignty is an office that gives one supreme or gives something or something or someone supreme authority. All right? Supreme authority. That's very important to understand what sovereignty is. All right? Supreme authority to act and to control the actions of others. Okay? Very, very important for you to understand sovereignty and its purest essence, the origin from which it originated. That's what we're going to discuss today. All right? So without further ado, we get started with this marvelous lecture. It is March 13th, 2024, which is the birth year 2974. This lecture on behalf of my queen, Sister Godwinson from the House of Godwinson, as well as our mediators, Archbishop Belmont from the House of Belmont, Countess Cersei, and all those who are here trying to get understanding of what it is that we are all called to do. All right. This lecture is also due is in lieu of the case that's before the Minnesota Superior Court in regards to statutes of frauds. Okay, who are committing frauds in regards to claims of ownership by way of having in possession a so-called deed. Okay, who actually has ownership of property by way of a possession of an instrument called a deed, which is nothing more than an instrument for conveying something from a buyer, a seller, a grantor to a grantee. Okay? Very important to understand that concept. We're going to discuss all that again today so that you all can have a clear understanding of what you're missing in regards to finding that true and direct line back to your birthright. It starts here at the English Third Temple Church of England. Okay? So let's get started. Sovereignty. sovereignty. Because every time you get pulled over and you start talking some talk regular to the norm, they always ask you, are you a sovereign? Right? That's what the authorities always ask because they assume that you're a subject. They want to offer the difference that they're saying that are you the sovereign? If they're not the sovereign, then automatically you're claiming to be the sovereign. And that if you're the sovereign, then how is that so? All right. That's our obligation to explain what's going on. Who is the sovereign? Greetings, Venus, Sister Countess Venus Walker. Good to see you. Who is the actual sovereign, or who has the sovereign authority and power to be able to speak on behalf of all subjects, on behalf of all issues regarding the sovereignty's estate? And we know that the state is called intel land, or what we call crown land, because we know that the sovereign represents the crown. We know the crown is the monarch. We know the monarch who's the one who sits on the throne, which has all the dual regalia and prerogatives to have that authority to set the standard or the social order for the body of politics, okay? I.e. the social compact or the social contract. Social compact, social contract is all falls under the authority of that sovereign power of the one who has the sovereign power. The question becomes, who gave him the sovereign power? How did the sovereign power come to play? And is the sovereign power is de jure or de facto? This needs to be understood by everyone, okay? Because we have what we call prescription of sovereignty. Prescription of sovereignty is when someone acts as if they're the sovereign without it being attested, all right? And that comes to what we call acquisition of sovereignty. We already discussed these terms in prior lessons. I don't have time to go through them again today. But sovereignty, if it's de facto, is by way of prescription. Everybody write that word down. Prescription of sovereignty. Prescription of sovereignty is de facto sovereignty. Contrast to de jure sovereignty, right? Which is what we call the absolute premier seisin. All right? The premier seisin, or the utmost highest form of possession. And we all know that's a allodial title. Allodial title. I hear some elder says she has the land titles. And Brother Rod Hayes, I guess he's associated with them. And this is also the notes to those who are affiliated with Native American tribes that she's calling on all matriarchs to form and come and form that body of politics in regards to the authority that they so-called have to receive the rights and charters to retain or retake or regain the land. All right. Nobody's just going to give you anything. You have to take it by force because it was taken by force under prescription of sovereignty through acquisition of sovereignty. Either it's by what we call conquest, discovery, secession. What else? Secession. What's the other terms? Let me get it right. Let's look it up. I want to be guessing. I just want to show y'all. Acquisition of sovereignty. This is what you all are up against. Acquisition of sovereignty. Acquisition of sovereignty is the number of methods of acquisition of sovereignty are or have been recognized by international law as lawful methods by which a state may acquire sovereignty over territory. International law adopted much of the Roman property law in regards to acquisition of sovereignty due to the underlying European civil law at the time of the early discoveries of voyages such as Christopher Columbus. Everybody see that? All right. The basis of acquisition of states' ownership of vacant territory therefore continues to apply. This is due what we call the eminent domain power of the state, or what we call acquisition of sovereignty, or what we call compulsory purchase of land, or what we also call eminent domain. This is called police powers. Everybody needs to write that down. Very important. These are the forms of acquisition of sovereignty, which is a form of de facto sovereignty, because de facto sovereignty is the factual ability to do something rather than the legal right to do something. Everybody needs to understand that. Accretion refers to the physical expansion of existing territory through geological processes such as alluvion or volcanism. Secession, a state may acquire sovereignty over territory if that sovereignty is ceded, transferred to it by another state. That's based off the Article 4, Section 4, the taking clause, if I'm not mistaken, or the property clause. Taking clause or property clause. Might be the taking clause. Also, the conquest, another form of acquisition of sovereignty. The direct annexation, the acquisition of territory by way of force, was historically recognized as a lawful method for gaining sovereignty over new acquired territory. This is also eminent domain power. Okay? Effective occupation for long periods of time. Effective occupation is the control of pretty new discovered territory exercised by a power with no sovereign title to the land. Whether it's defiance or absence of proper sovereign, several cases in international law have dealt with the effective occupation occupation entails. Hence that word entail, because entail is been given a loose meaning other than the tight meaning or the concrete meaning that it stems from abstract or contrast to be simple. Okay? Very, very, very important for all you understand that. And then we have prescription. Okay? Prescription. Prescription is related to the occupation and refers to the acquisition of sovereignty by way of the actual exercise of sovereignty maintained for a reasonable period of time that is effective without objection from other states and countries. Okay? This is called prescription of sovereignty. When somebody acts as the sovereign, right, but it's not the sovereign, but it's not being tested by the true sovereign, because the true sovereign, it seems not to be, is subject to what we call the interregnum. All right, this was done under the Republic, or what we call the Commonwealth. All right, under the Republic of the Commonwealth, and that's why you have what we call the statutes of frauds that which were created. Okay, this is why you have recorders of deeds which were created as a result of these acts that were committed by prescription of sovereignty on the acquisition of sovereignty in the term that denote to that type of acquisition. Okay, so what is prescription of sovereignty? So we can get an understanding of what that means. Prescription is the international law. So this is international, not domestic. All right? It's an international law. It's sovereignty transfer of territory by an open encroachment by new sovereigns upon the territory for a prolonged period of time, acting as the sovereign without protest or other contest by the original sovereign. It is analogous to the common law doctrine of easements by prescription. Okay? Whether it's de facto or de jure, prescription is allowed by easement of prescription in what we call real estate or estates and land by what we call feudal tenure. Feudal tenure has been abolished, and now those estates or land is through fee simple by a process that we all call in the Third Temple English Church of England common recovery. This was done by attorneys, all right, who are now your brokers, who have a license by every state to go out and sell real estate. That's what we call substitution. That's a violation of Queen of Pretorius that were passed by your ancestors, Edward the First, and that said that land could not be alienated from the heirs or the original owner. It can only be substituted, not alienated by subdivision by way of what we call fee simple possession. All right? Fee determinable or a life estate. Y'all have to understand these terms. I've been through them and I don't have time to go through them again as a result of the urgency of what's going to take place April 16th. Because April 16th, the day of our court hearing, is the actual day that the Statute of Frauds was created under Charles II, under the restoration of the Commonwealth of England as a result of what took place through what we call the English Civil War. The English Civil War originated as a result of what we call the Tenure Abolition Act. All right, the Feudal Tenure Abolition Act, and that stemmed from what we call the Great Contract. All right, so I'm actually going ahead of myself, but it stemmed from the Great Contract. All right, so easement by prescription for private real estate meaning under fee simple to which is a form of what we call freehold. All right, a form of freehold. So what is easement by prescription? Before I move forward, everybody who's watching, if you're watching, I hope you click at these terms as well with me. Easement. Easement is a non-possessory right to use in or to enter onto real property or another's without possessing it. When you read this, this goes for you as well. You are not an exception to the laws of our ancestors. All right? You're not operating under the laws of your ancestors because the laws you're subject to are the laws created through what we call prescription of sovereignty by way of acquisition of sovereignty. And this occurred in the 14th century. All right, the 14th and 15th century, which stemmed from what we call the feudal tenures. That's why they were abolished. All right, there was a fight over the estates that was passed through what we call livery of seisin, which was called delivery of possession. That goes back to a process that started back from seisin. All right, conveyance of property, which can be done by two ways: livery of seisin and livery of law. Okay, we're going to discuss all this today. So, let's take our time. So, an easement is a non-possessory right in the use or to enter onto real property. So it says non-possessory, all right? Non-possessory right to use or enter into real property of another without the possession of it, okay? That's what that means. Everybody read that, right? Okay, non-possessory right. A non-possessory interest in land is a term of law of property to describe any of the categories of rights held by one person. You hear that? One person to use land that is possessed of another. Such rights can generally be created in one or two ways, either by express agreement, i.e., a written contract, right? A written contract between the parties who owns the land and the party who seeks to own the interest, or by an order of a court. The order of the court is by the eminent domain powers of the court as a result of the acquisition of sovereignty. It can also be done without the order of a court if it's done according to the what we call ceremonial way of conveyance of property, which you have yet to understand. Okay, as a result of that ignorance, this is what you're subject to under the American common law. All right, under the common law, there are in 5 variations of such rights. These are easements, account profits, restricted covenants, equitable servitudes, and license. Okay, this goes into your brokers. All right, your driving license, birth certificate. All these instruments show a contract, and the contract is agreement between the giver and the receiver, the purchaser and the buyer. the grantor and the grantee. All right, which is a contract. But if you're ignorant of the contract, then it becomes unconscionable when the contract is agreed to, but you have to know the terms and conditions that the contract was made was unlawful. All right. This is only is a result by way of duress when you're forced to do this by undue influence, which is what we call a psychological control over your reasoning. Okay, your reasoning. We must understand that. So a non-possessory interest in land. So with that thought in mind, let's bring up the record of deeds. All those who have access to platforms that have a big congregation, if you're watching this video, I'm asking you to reach out to them so that we can get an invite to their platform that they will receive the truth. If they don't want to receive the truth, then they forever be damned because they'll be restricted from the book of life. We know the book of life is what we know in our English Anglo-Saxon. It's called the Doomsday Book. The Doomsday Book is called what we call Bookland, and the Bookland is called Brookland, which is recorded of all deeds that were recorded in the county recorder's office for non-possessory interests in estates and lands other than the right of true ownership or true possession. Okay, of true possessions. I don't know why I took them to Cook County. Okay, here we go. Yeah, I better be paying attention to what y'all reading. Recorder of deeds. All right. Frederick Douglass, a former emancipated slave who found out that he was of Anglo-Saxon paternity. All right. So they made a mockery of our great and influential leader, Frederick Douglass, as a result of what they did to him at the offset of the death of the land. And they put this man at the head of the hem of the ship or the machine that allowed them to take the land from us. All right. It was the recorder of deeds or the deed of registry, which is a government office tasked with maintaining public records and documents, especially records relating to real estate ownership that provides persons other than the owner of property with real rights over that property. That's called a non-possessory interest in land through acquisition of sovereignty by way of prescription of sovereignty by someone claiming to be the sovereign and they're not. And it has not been contested by the true sovereign. That means that that sovereign was acting in the capacity as a de facto sovereign, which has the factual ability. And we know a fact is under the laws of presumption, which can be proven wrong. A presumption in fact can be proven when another fact contradicts that presumption of fact. Okay? So it says that recorder of deeds gives a conveyance of a like or presumption of ownership and property when it actually does not prove that you actually own it. It's just a conveyor of property that was owned by somebody, but the question becomes, who is that owner? Okay? Who is the owners? Who is the owner or who are the owners of the said property? And that, of course, will only be the heirs. All right? That's why the statutes of frauds was created. All right? Everybody hold that thought. Sorry about that. I want y'all to know, don't think that I'm just talking out my ear or talking out the talking 1 second. I really want y'all to understand that I'm not just talking for nothing. If you're an officer of the Third Temple English Church of England and you don't understand these lessons that I'm giving you, because you will be questioned about this. All right. What I'm telling you, you must be on the same frequency I am. If you're not, you will be removed. Okay? You will be removed if you're not dropping it like I'm dropping. All right? I don't want to have no excuses. You have no excuses. All right. Real estate ownership that provides person other than the owner of property the real rights over the property. This is called a bundle of rights. Okay? A bundles of rights. So we know a recorder of deeds gives rights to people other than the owner of it. If this is the case, then this is what we call acquisition of sovereignty. What form of acquisition of sovereignty takes place is yet to be decided. But we know it all is a form of prescription of sovereignty. Somebody claimed to be the sovereign and it is not until this day. Because I'm telling you that I am the sovereign, and I'm the sovereign by right of law. Right? We have a we have a factual ability to do so and a legal right to do so. A legal right to do so is different than a factual ability to do so. Okay? That's what I'm going to show you, contrast to what you've been seeing by everybody else who claim to have an interest in these lands here, what you call North America. All right? So once again, all right, we have two forms of sovereignty in regards to the sovereign power over property, all right, that's filed in the recorder of deeds, all right? One is de facto and one is de jure. I'm sorry. All right, I'm going to stay too long on this. Recorder of deeds. So let's go back to acquisition. Prescription. All right. Prescription of sovereignty. So it's like a checkerboard. You got a checkerboard, which is a square. All right. Let's call that a sob. All right. Let's call that let's call that the allodial land. All right. Pay close to all the terms I'm using because they're going to come up later on in this class. So let's say that the checkerboard is the allodial land. All right. And the ceremonial way, other than how they do it today under common recovery, which we know fee simple, was done by way of what we call ceremonial conveyance. All right. Or the or what we call the ceremonial or what they say, ceremonial or another word I want to use, ceremonial conveyance. All right, we're gonna use that just for now. So there's the ceremonial way of conveyance and the modern way of conveyance. All right. The ceremonial way of conveyance is not the modern way of conveyance because the modern way of conveyance is by having the so-called conveyance qualified by way of an agreement, i.e., something written up in writing. It had to be a written agreement, a written contract. All right, to show proof and that there was no defrauding the creditor. All right, the grantor. All right, we want to make sure that the agreement between the grantor and the grantee and the stipulation or the encumbrances based off the conveyance of the land was stipulated. All right, whether they're encumbrances, whether they're reversion clause, warranty clause, all these stipulations had to be in that specific contract or agreement, which you now call a deed. All right, in the form of conveyance, whether it was done by what we call a will, last will, or testament, or by way of what we call a deed by charter, or by a way what we call incorporation. There's many ways that you have the ability to convey property, but is that conveyance of that property legal or presumptive in law? Okay, that's what we need to ask ourselves. All right, so we know prescription and sovereignty in international law, it's a sovereignty transfer of a territory. And when we say territory, we're talking about the land. All right. That can be federal land, state land, what you call public land, or what we call Commonwealth realms. All right. That's what we're talking about. If you ain't talking about public land, state land, or public land, state land, federal lands, or the public domain, which we call the Commonwealth realms, then how you claim to be sovereign on land that you don't exist on? Nobody asks that specific question. How are you a sovereign not being on any land owned by a sovereign? Because apparently you're not the sovereign because right now you're subject to what I'm talking about now. Prescription of sovereignty through acquisition of sovereignty, which is a non-possessory right and use some property that you don't own, because the only thing you got as proof of ownership is a deed. Y'all don't hear me. The doctrine legalized the jure and de facto transfer of sovereignty caused in part by the original sovereign's extended negligence in or neglect of the area in question. Plain, point, and simple. It is the sovereign's negligence that denotes to whether it becomes de jure or de facto. Okay? De jure and de facto. We're going to look at this from a concrete perspective versus abstract, because we know that de facto sovereign at this time was the House of Stewards. All right? The House of Stewards from James I all the way up to Queen Anne, all the way up to King George, who they passed it on to, were de facto sovereign monarchs from the House of Stewart, acting on behalf of the Great Britain, which was the British Parliament established in 1707. All right, but none of the laws that were passed by the Great Britain by the Union of 1707 with England, Ireland, and Scotland, none of those acts that were passed were on behalf of Ireland and Scotland. They were on behalf of the Parliament of England, which bears a different heraldic livery, because we know a livery is a badge, all right, of nobility. All right, we know that the House of Stewards were acting as de facto sovereign, but really they were common. They were common. You can prove this. No mess, no questions. Nobody got no questions. I only see two people in the chat. We have four. That's all right, because I'm gonna remember that. Okay, remember that. So let's entertain sovereignty for a minute. Oh, I got it right there. Sovereignty. Everybody listen very close. If you want a definition of sovereignty, this is where you get it from. And I'm going to use Wikipedia just to qualify. Sovereignty can generally be defined as supreme authority. Sovereignty entails, there go that word entail again. Did you hear that? It entails hierarchy within a state. Once again, sovereignty is generally defined by supreme authority, which entails a hierarchy within a state, colony, province, etc., as well as external autonomy for states. Okay? Entails, very, very important word when it's used as a noun, not an adjective. When you use it as a noun, it denotes to the state left for a beneficiary or heirs that was passed by who? Edward I under the Donors Conditionalibus, the Statutes of Entail. All right? So we talk about sovereignty, which entails a hierarchy within the state. Let's look at Statute of Donors Conditionalibus. Greetings, Archbishop Alfonso Belmont. Look at this word, y'all. Look at the words. The Donors Conditionalibus or Estates Tales Act of 1285 is a chapter of English Statutes of Westminster in 1285. It originated the law of entail forbidding landowners to sell his land except to his heirs. Did everybody see that? So we're showing you that the connection that the Third Temple English Church have to our ancestors going back to time immemorial, and we know time immemorial, according to law, goes back to Richard I, son of Henry II, son of Godfrey V, Count of Anjou, son of folk. When we know folk land is where book land, or what we call allodial land, came from, to the original conveyance, ceremonial conveyance, or the original conveyance of property, which what we know as livery of seisin, which we're going to talk about again today. Thank you, Archbishop. All right. What is entail? Since we know sovereignty entails the hierarchy of a state, so what is entail? Because it said the hierarchy entails the sovereignty of a state. All right, that has the supreme authority to be able to make laws and amend the laws for the sovereign people. All right, for the sovereign people. A former entail has been known before the Norman penal law has been domesticated in England. The common form was a grant to the fealty and the heirs of his body. Okay, so that means that crown land is entail. So the only way you had an interest in that entail land, you had to be a member of the crown. And we know crown land was incorporated through the Third Temple English Church because we know the crown represents or is personified by a natural person called the corporation soul. All right? The common form was a grant to the fealty to his heirs of the body with limited limitations in which it was sought to prevent alienation from the lineage of the first purchaser. These grants was known as feudal conditionata because if the donee had no heirs of his body to the state, reverted to the donor by escheat. Everybody know what that means, right? Escheat. The right of reversion or remandment was evaded by the interpretation that such a gift was a conditional fee, which enabled the donee, if he had an heir of the body born alive, to alienate the land and consequently disinherit the issue and defeat the right of the original donor. To remedy this statute, the donor's conditional abyss was passed in what? Edward I in 1285. You're reading it for yourself. All right, Edward I. He was of the Plantagenet crown. Plantagenet crown was established by Godfrey V, Count of Anjou, son of Folk, ruler of Jerusalem. Okay, there you have it. Let's go ahead. Back to sovereignty. Sovereignty entails hierarchies within the state as well as external autonomy for state. In any state, sovereignty is assigned to the person, body, or institution that has the ultimate authority over the people in order to establish laws or change existing laws. I just said that. That's the difference between a corporation. So the crown and the commonwealth, which you call a republic. Okay? Y'all better listen to me, because if you made your choice now, you are making your choice now. You better make it now before I have to make it for you. In order for a state sovereignty to assign to the person, body, or institution, body or institution is the body of politics. That's a social contract between the social compact between the individual person and the representation, whether it's a group of people or an individual that has the ultimate authority over the people in order to establish a law or change existing laws. In political theory, sovereignty is a substantive term designating supreme legitimate authority over some body of polity, i.e. public entity called a polity, which is a state, commonwealth, colony, etc. All right? In international law, sovereignty is the exercise of a power of a state. All right? De jure, listen, y'all. De jure sovereignty refers to the legal right to do so. Contrast to or abstract to de facto sovereignty, referring to the factual ability to do so. This can become an issue of special concern upon the failure of the usual expectation that de jure and de facto sovereignty exist at place in times of concern and reside with the same organization. Did y'all hear that? This is going to scare a lot of y'all. All right? This is going to scare a lot of y'all. So you know the difference between sovereignty. You either have a de jure or de facto. If it's de facto, it's for something until proven wrong. And if it's proven wrong, that means that it wasn't de jure from the door. It was through prescription of sovereignty. You acting like you're sovereign, but you really was not. Okay? As you can see, the same picture of Leviathan and Leviathan versus Thomas Hobbes. You see one individual, not a group of individuals. All right? One individual, not a group of individuals. You got corporation soul, aggregate, and a corporation soul. One natural person. All right, so with that, let's move forward. Where do I want to go? Let's establish some principles right here. A foundation. 1947 Constitution of the State of New Jersey, as well as the 1844 Constitution and the 1776 Constitution, recognize the authority of our descendants who were Anglo-Saxon. This is on New Jersey courts. All right, it's on their website, and this is who suing me. I got a claim on April 16th The day the statutes fall created to prove that the deeds that are on the county right now are frauds. All right? That's what I'm going to prove. Why? Because we are the people who conveyed deeds in the original ceremonial way versus the modern way that is done as a requirement that was created by the Statutes of Frauds in 1677, which was passed by who? Parliament of England. Parliament of England passed that. All right. Beginning being one of the original 13 colonies, New Jersey has been strongly influenced by English law and the Anglo-Saxon traditions. The three branches of government enshrined in the United States Constitution and the New Jersey Constitution are derived from English history. The king was the executive branch, Parliament, the legislative branch, the court, the judicial branch. It was an English judiciary that a formal civilized system for resolving disputes and addressing crimes. You hear that? Crimes originated amongst the English-speaking people. So if you're English-speaking people, but don't have an English nationality, then this does not apply to you. Okay? If you're not Anglo-Saxon, then this does not apply to you. The government does not have to protect you because the social compact involving the sovereignty concerning the intel hierarchy of the state, which was the ability to make the laws and amend the laws on behalf of the people to maintain the social order, originated from the Anglo-Saxon tradition, and we know that's ceremonial because you can't do nothing on land that you don't possess. If it's done, then it's not de jure. All right. It was in the early courts in England that the common law took root and evolved into our current system of court, judges, and juries. The common law we know today dates back to the 12th, 13th century and derived from the reign of King Henry II, who appointed judges to resolve disputes among his subjects because trial by jury was created by Godfrey V, Count of Anjou, son of Foe. I got case law to validate that. All right, let's just make sure we know that this comes from New Jersey courts. Everybody see that, right? Official website of New Jersey Judiciary. Right there. A PDF. So everybody want the PDF copy, please go there and get it. It's right there. Right there. Plain writing. All right. It also says, pay closer to what you're reading. Yeah, a lot of people just look right over it. All right. You read right over this. Hence the word commoner. Very important. The meaning of the term common law was twofold. The English courts of common pleas addressed issues arising from quarrels among the commoners, and the mission of such courts was to create a collective body of law based upon local custom that is uniform system of law common throughout all England. So the laws common to England was those common to the true heirs of England, not those commoners, all right? The commoners were those who took the right of the Englishmen as a result of them having the rights of their own. All right? You didn't have any rights. The rights that you have was established in your Constitution, which was an instrument not granting right, but was an instrument of limitations. All right? You had to, in lieu of right of possession, especially in regards to property, you had to do that by Article 4, Section 4, do what we call acquisition of sovereignty. These are undisputable facts, okay? Evidence that I'm going to present on April 16th, the day the statute of fraud was created. Because you saying us at the English heirs and successors, descendants of Godfrey the Count of Anjou, who Henry II you got here on your website, was our ancestor. It was an heir who sat on the throne of England and France, governed the territories over here known as New France and New Spain, prior to you getting to Great Britain. All right? You got to know this history. Let's see. So let's find some more sources. All right, let's move from here. Let's get there. This is what I'm using for court. No one is able to use this but me. All right? No one else can use this but me. You tried, you got to deal with me. Everybody see that? State of New Jersey Law Revision Commission. Draft tenant report related to property, July 2012. Okay? Right there. Everybody see it. This deals with the state of New Jersey in regards to property governed under Title 46 of the Jersey Bond Statute. All right? Everybody look that up. Get that, pull that up. Especially my officers. All right, let's get there. This is what our public defender is going to be bringing before the prosecutor for the state of New Jersey. This is what we're going to use in our what we call affirmative defense. All right, we're going to raise an affirmative defense and a negative defense to take the attention off us, and put it on them. All right, everybody heard of that term? Affirmative defense, negative defense. These are strategies in criminal prosecutions. All right, which falls under the statute of frauds of 1677, which was the act created by Parliament, because they're saying that there was a self-generated deed in lieu of ownership. We know that the statutes of frauds in lieu of unlawful conveyances, in lieu of discrediting the creditor, they created the recorders of deeds to record every deed in writing to prove that the parties conveying it were the true parties in the original contract as a result of fraudulent conveyances that were done prior to the creation of the statutes of fraud. Okay? Very important for y'all to understand that. New Jersey Law Revision, draft tentative report on property. What was the report about? Let's read it in a nutshell. The statutes that they're talking about is Title 46 that deals with right of possession. All right. They got Title 46 3-1, 3-4, 3-9, and 3-4. They left out the most important statute. That's 46 colon 3-2. They left it out. There's a reason for it. Okay. No one is able to bring this revelation, this realization to you, but your king. That's why they left it out, because it involved the king. King, body politics, person, corporate. All right. It says there, comments in regards to the law revision report on amending Title 46. It says, this section contains streamlined and consolidated language from the source section as follows. A, it is taken from 46 colon 3-1. B, it is taken from 46 colon 3-5. That's Queen Imperatrice Terrum. It's taken from 46 colon 3-14. And it's taken from 46 colon 3-4. Real estate, the rule against perpetuities, and F is taken from 46:3-9 of New Jersey Revised Statute. We all been to little statutes before. We've been to little statutes before, so I'm not going to go through them again. If you want to go through them again, you do it at your own time. But the most important statute is 46:3-2. All right? Next paragraph. The phrase, be simple, has been used to indicate ordinary title to real estate. It has been substituted, you hear that? Substituted for the free and common soldiers. So they exchanged fee simple from free and common soldiers. So they interchanged it, okay? They removed free and common soldiers and fee simple. Why? Because they wanted the money. Not give it to the king because they left out 46:3-2, which deals with the free and common soldiers that's given to the king or another person that sits in the position of a king, operating under the body of politics through its incorporation, through its person as corporation. So, all right, these are called the Abolition Tenure Acts of 1660, an act passed by Parliament by Charles II. All right, by Charles II. I'm not just quoting, we're going to go through it. The phrase fee simple has been used to indicate ordinary title to real estate. It has been substituted for free and common soldiers, a phrase used in some of source statutes. So they're saying the free and common soldiers was used in some source statutes under Title 46, but they're saying that the transparency and the understanding is vague. So this is the reason in the courts for amending it, which I find very alarming. Okay, I find it very alarming. Let's see why. The phrase has a number of meanings, but in the context, it is identical to fee simple. Fee simple is also intended as equivalent to allodial, a word used in some of the older cases as meaning a form of ownership not subject to any rent, services, or acknowledgement to a superior. Now they're saying that here that fee simple is equivalent to allodial, but we know fee simple and allodial is not the same. All right? New Jersey is trying to tell you that they're equivalent, but I'm telling you, and the law is going to tell you that they're not the same. Okay? Why are they not the same? It's the question. Let's see. Allodial title. Everybody pays very close attention. Allodial title constitute ownership of real property, land, building, and fixtures. All right, that is independent of any superior landlord. Allodial title is related to the concept of land held in allodium, or land ownership by occupancy and defense of the land. Most property ownership in common law jurisdiction is fee simple. All right. In the United States, the land is subject to the eminent domain by federal, state, and local government, and subject to the imposition of the encumbrances of taxes by state and or local governments. And there is thus no true allodial land. Some states within the United States have provisions for considering land allodial under state law, and terms may be used in other circumstances. Land is held of the crown in England and Wales and jurisdictions in the Commonwealth rim. That means land that's entailed is automatically crown land, because crown land cannot be alienated by way of the eminent domain powers of the state, which is to pull these powers that the state or the federal government have by way of issue when there are no heirs as a result of what we call intestate. Do everybody understand that? Do you understand that? So there is no fee simple that is equivalent to what we call elogio. We're gonna go even further to prove and validate that what the New Jersey Law Commission is saying is totally false. All right, that's not my burden of proof that I got to meet. That's their burden of proof that they got to meet in lieu of Title 40, in lieu of Title 40, in lieu of what we call the Law Review Commission. All right, because the state of New Jersey is the one who's the plaintiff in this matter. And once again, the phrase fee simple, this is your focal point. The phrase fee simple has been used to indicate ordinary titles to real estate. It has been exchanged for, substituted for free and common soakage. All right? So fee and simple has been exchanged from free and common soakage. So the free and common soakage is being done, has not been the meant use to gain finances for the crown under what we call the Feudal Tenure Abolition Act of 1660. All right, under the original what we call the Great Contract. All right, anyone of you heard of that? The Great Contract by King James I. If you didn't, you're gonna learn about it today. All right. So fee and common soakage has been replaced with fee simple, and now fee simple is considered to be equivalent with allodial. We here at the Third Temple English Church of England got a problem with that because we know that under the statutory law, it says ain't no feudal tenure and the land remains allodial. Fee simple is not the same as a feudal tenure. All right, deed. All right. Whether it's filed in the deed, recorded by way of the Statute of Frauds of 1677 in regards to all agreements being in writing, or whether it was done by livery of seisin. All right? Either of those two ways, they're not the same as fee simple. All right? Fee simple is common recovery that under the Taupin case was abolished that turned entail state into fee simple states. All right? Let's get it. New Jersey Law Review Commission. It's another law review commission that was done in final report filed in 1991. All right. Everybody see this. So I'm not making this up. Reports and recommendations relating to the statutes of frauds. All right. The statutes of frauds. Y'all better listen to me if y'all ain't never listened to me before. All right. First of all, what is the statutes of frauds? The statute of frauds is a form of statute requiring that certain kinds of contracts be memorialized in writing, signed by a party against whom they are to be enforced, with sufficient content to evidence the contract. Okay? Everybody see that? That was passed, not this one. That's this is it. Bear with me, y'all. Statute of frauds. Where's the original? Statute of frauds. All right. Very important. We're not going to use the term statute of fraud loosely. That's what they want you to do. All right. We know a statute of frauds encompasses contracts being writing to prove as evidence before a court who are the actual parties and have an interest in the property by way of the conveyance that's validated by that instrument, which you call a deed. All right. Which you call a deed. So a statute of frauds passed by Charles II in 1677 was an act of the Parliament of England. It required that certain types of contracts, wills, and grants, and assignments or surrenders or leases or interest in real property must be in writing and signed to avoid fraud on the court by perjury and subordination of perjury. It also required that documents of the court be signed and dated. This act was passed by who, everyone? The Parliament of England. It didn't say Scotland. It didn't say Ireland. It said the Parliament of England. The Parliament of England was established in the 12th century by Henry II. Okay? Henry II. So Charles II passed this statute, which is the act of Parliament by the King, not the United States, not Congress, but the Parliament of England in 1677, requiring that all contracts, wills, grants, assignments, surrenders, leases, interest, and real property conveyances, etc., be in writing to avoid fraud on the court by perjury or trying to rob the creditor of his debt. We must understand that. And who passed it? Charles II. Charles II was operating under what we call a republic or a commonwealth. All right? A republic or commonwealth. There was no body of politics associated with the monarch. Okay? All right? So if the monarch ain't there, they can do whatever they want with the heirs because the heirs' sovereignty depends upon the representation, whether it comes from a body of politics or what they say a polity, which is a group or a body, or whether it's from one individual, one person. All right? And associate that power of that one person with the power of sovereignty, with the ultimate authority to be able to set laws, amend laws as required, as established in that office, which entails in the hierarchy, entails the hierarchy of the state. Okay, we must understand this language. All right, because if you don't understand this language in regards to all contracts that are in mobility right now, then guess what? You're committing fraud on the court. I'm going to prove it. I don't care who you are. If you're not an English heir, the laws passed by the de facto monarchs under the presumptive ability to pass laws, put laws in place that had a legal effect because they had the legal right to do so in regard to who they represented and sitting in that office as what we call the representation based upon the social compact and the social contract that the people surrender, all right, to them. Yes, you are. You are assumed, as they assume, that you own the prescription of sovereignty right now. You're exactly right. All right. So under the prescription, because that's what they practice. That's their mode of doing business under prescription, acquisition of sovereignty. They claim they're sovereign, right? Whatever the people didn't surrender to them under the Articles of Confederation, the states maintain under the colonies or the Confederation. All right? So yes, you are under prescription, and we know prescription is by way of somebody claiming to be the sovereign. We know slavery was instituted by Great Britain in 1707, which was not the Parliament of England. It was the Parliament of Great Britain. This act was not passed by the Parliament of Great Britain. It was passed by the Parliament of England by a Scottish monarch sitting on the Parliament of England as a Scottish king, de facto. Okay, we got to be able to see these clarities. You got to have the eyes to see this. All right? Because they're letting you know that they ain't gonna be the ones caught on the fraud. You're gonna be the one caught on fraud because you adopted their process, which was established under the House of Steward, which we call a commonwealth. All right? The new mode of conveyance. I'm gonna prove it. Let's get there. Statute of frauds. Now we have what we call the statutes, King Abolition Act. Y'all better listen. Now we know this New Jersey Law Commission said, if y'all remember what y'all seen by me presenting it, which I'm pretty sure y'all forgot already, it said that fee simple was equivalent to allodium, right? That's what they said. Fee simple was equivalent to allodium, and they exchanged fee simple with free and common soakage. They substituted fee simple for fee and common soakage. Let's see it for ourselves. I'm not lying. Right there. Everybody read that. Read that. Everybody see it? Who is able to reveal light like that? Well, I thought. I can't stress enough. If I'm holding them liable to what they're doing, why shouldn't I hold you liable for what you're not doing? Okay? You're in a worse position than they are. They have an excuse. You don't. All right? Because I'm here now. Just because I'm here, they ain't going to make them change, but it should make you change. All right? The phrase fee simple has been used to indicate ordinary titles to real estate. It has been substituted for the free, common, soakage, a phrase used in some of sources statutes. Okay? Fee simple has been changed to free and common soakage, has been used in some of the sources of the statute. You're going to hear that in New Jersey's Law Review Commission again. All right? Let's go here. Senior Abolition Act. Senior Abolition Act by Charles II. He passed it for who? The Parliament of England. That's our seal. That's heraldic seal. That's our what we call heraldic livery badge, so that we can reclaim the possession, do what we call livery of possession. All right? Livery of possession originates back from a lolio title. Okay? Do what we call Inquisition post mortem. I repeat, Inquisition post mortem. The King Abolition Act by Charles II, the same one who passed the Statute of Frauds, sometimes known as the Statute of Tingers, was an act of Parliament in England, not Scotland, not Ireland, not Great Britain. Changed the nature of several types of feudal land tingers in England. The long title of the act was the act taking away the court's wards of libraries and the tingers of capitite and the night services and purveyances and for settling the revenue upon his majesty and lieu of thereof. This is based upon what we call the Great Contract. Anybody ever heard of that? Anybody ever heard of the Great Contract? Let's talk about it. Passed by the Conventions of Parliament in 1660. That's the restoration of Charles II. Shortly after the English Restoration, the Act replaced various types of military and religious services. The tenants owned to the crown with socads. You hear that? And compensate the monarch with an annual fixed payment of 100,000 shillings. I don't know the numerical value for that symbol, so forgive me, but it's 100,000, whatever denomination that is, to be raised by means of new tax or alcohol. Frank Lemoyne, copyhold, and certain aspects of grand sergeantry were excluded. It completed a process that had begun in 1610 during the reign of James I with the proposal of what we call the Great Contract. Did you hear that? They were trying to raise money for the English crown as a result of what occurred through the times of what we call the War of the Roses. All right? Very important to understand that. For you to understand that, we got to talk about Queen Imperatrix. All right? Queen Imperatrix. We got to talk about that. We're going to do that. Great contract. It's in writing, y'all. But it's not done the way we do it now, by way of county recorders and recorder of deeds registry. It's not done that way. All right? It was done under the ceremonial way as our ancestors did in the olden days, which you have no knowledge of. William Penn took advantage of this process. All right? The state of Pennsylvania was founded on the ceremonial process in which our ancestors did it. Okay? We're going to talk about this, y'all. Great Contract was a plan submitted to James I in Parliament in 1610 by Cecil. It was an attempt to increase crown income and ultimately rid it of its debt. Okay? You know who Robert Cecil was, right? Let's look at him. Very influential guy. From the Salisbury family, from the Cecil family. Everybody listen. Robert Cecil, 1st Earl of Salisbury, was an English statesman noble for the direction of the government during the Union of the Crowns. As Tudor England gave way to Stuart's rule in 1603, Lord Salisbury served as Secretary of State of England and Lord High Treasurer, succeeding his father as Queen Elizabeth's first Lord Privy Seal and remaining in power during the first 9 years of King James I's reign until his death. Okay? So the Great Contract in regards to the Feudal Tenure Abolition Act in 1610 goes all the way back to 1603, dealing with King James to raise revenue for who? The Parliament of England. All right? The Parliament of England. Let's look at fee simple real quick. Common recovery. Anybody, in case anybody got a problem, misunderstanding about common recovery. I got a case that's going to make that a little bit more clear for everyone. Imagine your king in that courtroom. All right. Yes, sir. I'm past the bar. Explain problem. Bear with me. Hold on. All right, see that? Yes, sir. You see Dred Scott for that clarity. When they took over the land by fraud, they took the people because they were chattel property. You were personal property. You were inventory. All right. Well said, Archbishop. Maybe this should bring some clarity to you. Common recovery was a legal process in England that enabled lawyers to convert entail, they're going to word entail again, estates, a form of land ownership called fee tail, into absolute ownership called fee simple. This was accomplished through conversion or collusive legal processes, some part of which were fictional and others unenforceable and therefore null and void. Everybody see that? So it was a process of common recovery done by lawyers. That's why when you receive property based off the contract, how they're conveyed, the deed and conveyance has encumbrances because the title insurance company nor the attorney's opinion based off the abstract title research done on the county recorders can validate an indefeasible title, which you assume that you have. You're thinking that the property is actually yours when the property is not yours because they can never prove that when they conveyed it, it was conveyed by the original grantor. They're not the original grantor. They just got a license based upon the police powers that are allowed by the state through its eminent domain powers through what we call acquisition of sovereignty. All right? We must understand that. I ain't got time to research, go through it. So if you don't, you need to go back and watch the other videos. You can't cheat here. All right. That's it. Where was it? Yeah. Great contract. The great contract. The great contract was a plan submitted by James I of Parliament in 1610 by Robert Cecil. It was an attempt to increase income and ultimately rid the crown of its debt. All right? Who was this Robert Cecil? Once again, Robert Cecil, noted for his direction in government during the Union of the Crowns, as Tudor of England gave way to the Stuart rule in 1603. Lord Salisbury served as the Secretary of State, Lord High Treasurer, succeeding his father as Queen Elizabeth I, Lord Privy Seal, remaining in power during the first 9 years of King James I until his own death. The principal discoverer of the gunpowder plot of 1605, Robert Cecil remains a controversial historic figure, as it is still debated at what point he first learned at the plot, to what extent he acted as an agent provocateur. All right, this goes back to the gunpowder plot. Everybody remember that movie, People for Vendetta? All right, that story is the abstract story to the actual act story that's taking place now. Which was a plan to raise money for the Crown of England once the Crown of England was usurped by the affiliation with the House of Stuarts, with the House of Tudors, through what we call the treaties of perpetual peace. They had two treaties of perpetual peace. All right, I ain't got time to go through them. I've been through them already in my prior classes. So if you ain't up on them, you need to go through that right now. For the sake of time, let's move forward. So the statutes of frauds were created by Charles II, as well as the statutes of tenures, were created by who? Charles II. The statutes of the tenure of abolition, Tenure Abolition Act. All right, let's go here. So the Tenure Abolition Act of 1660 was an act passed by Charles II at the restoration of Parliament, because Parliament at that time was acting in what we call the Commonwealth or Republic. All right. All right. The conveyances of land that were done under the Republic or Commonwealth was unlawful, because at these times, the attorneys that were acting on behalf of the Parliament of the Scottish kings and queens were de facto in their office. The nature of the office was de facto in nature. They were just like co-conspirators. All right, co-conspirators. Okay. What is the language of the Tenure Abolition Act? All right. What is the language? Everybody look at the language. They just said in New Jersey Law Commission that fee simple was the same as free and common soakage. Didn't they say that? Fee simple was the same as free and common soakage, and free and common soakage, it says fee simple substituted for free and common soakage, and that fee simple was the equivalent to elogio. This is the evidence that I'm going to use to incriminate the state of New Jersey and their law commission, who revised our laws without the authority to do so. All right? Because they assumed that we were not here. It said, and that all things hereafter to be created by the king's majesty, his heirs or successors, upon any gift or grant or manors, lands, tenement, or hereditaments of any state of inheritance at the common law, should be in free and common soakage, and should be adjudged to be in free and common soakage only. And not now, what they did is amended the statute and took out certain languages, but left the remedy of the statute intact. How we know it? Let's go to the New Jersey revised statute that was the amending of the statute of Parliament pertaining to the Tenure Abolition Act. Okay, let's go to the actual statute. 46:3-1 and 46:3-2. Yes, they did, Archbishop. We're going to go back to it just to qualify. New Jersey revised statute. Tenure Abolition Act. That's right here. At the same time, Charles II was reigning. The freedom tenure estates and instances thereof taken away, discharged, and abolished from and after March 12, 1664 by Section 2 of an act concerning tenures passed away February 8th, 1795, shall continue to be taken away, discharged, and abolished, and no such estate or incident thereof shall at any time be created in the manner thereof. That's part of the Tenure Abolition Act of 1660, and the other part of it is part 2 of it. They think they slipped. This is the free and common soakage aspect of it. All right. So they say everything given from March 12th, 1664, that was the time of Charles I. We know that Charles I gave a charter or a deed of conveyance to George, what we said, George Corrett and John Berkeley, where they surrendered back to the crown in 1702. All right. We also know that Charles II also gave charters to William Penn on behalf of their attorneys in lieu of what we call land conveyance, which we'll discuss shortly. Okay. Which was under the province of Pennsylvania. Okay. Which was under the province of Pennsylvania. So it says here, the tenures of honors, manors, lands, tenements, or hereditaments of estates of inheritance at the common law held either by the King of England or any other person, body, parts, or corporate at any time before July 4th, 1776, the day they declared their independence, declared by Section 3 of an act entitled Act Concerning Tenure, same act, abolition of tenure of 1660, passed February 18, 1795, to be turned into free and common soakage, not under free and simple. Free and simple is not the same as free and common soakage, and free and simple is not the same as allodial, because if it was, there would be a king. As it said here, a king of England, other person, body of parties, or corporate. So they usurp the prerogatives of the crown under the authority of the crown, which was the legislative laws you're reading now in regards to the abolition of feudal tenures that they have in regards to what's found on the county recorders, which is giving property to people other than the original owner or the grantor. And this was done by way of the creation of the recorders of deeds or the county register in regards to the filing of fee simple deeds. All right, through the process of common recovery, which is normally done in 4 ways. Abstract title, right, which involves the attorney's opinion. Torrens title, which if the attorney's opinions don't match up, then that means that you need insurance to cover your injury as a result of somebody putting a lien on the property in lieu of claiming that they are the owner of that said property. All right, so you have abstract title, or what we call a property abstract, which is a search of the county recorders or the county register. Once that search is done, then it becomes an abstract, property abstract, which is drawn up by an attorney, which signs off on it by giving his opinion that, as far as he knows, that there is no claims or liens on the property at hand that was filed by way of the deed in lieu of the conveyance. Whatever conveyance that may be is left up for discretionary. But it's also saying that just in case, you have to get title insurance. And title insurance is to compensate you for damages up to a certain amount as a result of your loss of somebody has a more equitable interest in that estate that you had a legal interest in. All right? Very important for you to understand that. Very important for you to understand that. All right? So the only way you can actually get an indefeasible title is through what we call Torrens land title. Torrens land title is the original search of the land registry, going back to what we call the original grants or deeds granted by those who had the authority to grant those deeds by way of conveyances, in which we call feudal tenure. Feudal tenure. Everybody up to speed? I hope so. Let's get there. So 46:3-2 and 46:3-1 is the statute dealing with abolition of tenures that was passed by Charles II in 1660. All right? Where's that? Right here. So that free and common soakage was supposed to go to the king. They took the king out of the equation. We see that right here. Because that statute, 46:3-2, right? Everybody look at the statute. Look at it. 46:3-2. Certain tenures holdings turn into free and common soakage. And you see king there. All right? You go back to the Law Review Commission dealing with Title 46 property. And this is what you have. This section contains streamlined, consolidated language from a source section as follows. A is taken from 46:3-1, which is the first one. That's the same act Charles II passed. Feudal tenures is abolished. All right? But they left out 46:3-2, which we just read. Why? Because they said the phrase fee simple has been used to indicate ordinary title to real estate and has been substituted for free and common soakage. All right? So free and common soakage only given to the king under his jury regalia. Ain't no king, so the only way they can gain it by way under their ceded power through what they call eminent domain power or compulsory power or acquisitional power through prescription through what we call non-possessory use is through fee simple, which they claim to be allodial. Because, and we just read the highest form of ownership in the state or the United States is fee simple. Therefore, there is no allodium, a word used in some older cases as meaning a form of ownership not subject to any rent, services, or acknowledgement to any superior. If the United States owned land allodial, then why in the hell was they raising taxes? All right? And who are you paying those taxes to? It ain't us, the citizens. All right, let's make this picture clearer. All right. So the 10-year Abolition Act, Title 46, property. All right. Fee simple has been substituted for free and common soakage. That's one lie. Fee simple has assumed to be equivalent to allodial. That's another lie that they got caught in. All right. Let's go ahead. We know when you're dealing with property, property falls under the statutes of frauds, and the statutes of frauds were created by Charles II in 1677 on behalf of Parliament of England. So if any of those deeds filed for the county record does not go back to the original grantor, which is the Parliament of England under the Commonwealth, by those monarchs, which he said, according to 1660, all through the things that were given by from the great contract from James I all the way up to 1664, as provided by the statute, has been abolished. Okay? So if it's been abolished, then how in the hell is the state of New Jersey claiming to have the authority to file fee simple deeds in a county record as under the assumption that they actually own it? Right? How? Because if they don't prove they own it, then that falls under the fraudulent conveyance, which falls under the statute of fraud. And this is qualified by who? New Jersey Law Review Commission. All right? Everybody see it. All right, everybody put it up. All right, everybody ready? No questions? And we only got 2 people watching. It's all good. New Jersey statutes of frauds. From the Jersey Law Review Commission. The statute of frauds, New Jersey Law Review Commission make reference to it, the statute passed by Charles II for the Parliament of England. All right? We've seen the actual statute ourselves. So there's no confusion about who he passed the law for. Okay? And he was actually working for the Commonwealth. All right? Under the interregnum, there was no de jure sovereign at that time. All right? Who had the legal right to do so. It says here in limits that the New Jersey statute of frauds, now known as New Jersey Revised Statute 25:1-1, 1 through 9, like similar enactments in every state, derives from the statute for the prevention of frauds and perjuries passed by Parliament in 1677, 29 Charles II, Code 3. Everybody see that? This is the New Jersey Law Commission. Every state has passed their own amendments of this actual statutes of frauds in regards to all contract in lieu of conveyances be in writing, dated, and signed so that it will protect against defrauding and perjury in lieu of subordination in lieu of the creditor. All right? We must understand that. So if that is the case, then the English statute, not the Scottish statute, not the Irish statute, totaling 24 individual sections, included provisions that require transfer of lands to be in writing, discouraging transfers of land and defrauding of judgments and creditors, and oppose formalities on all wills of personal property. We know the Crown Act of 1541 says that the Crown has first dibs in all debts from any debtor. That's including his subjects or their subjects. All right? Let's move forward. The first 5 sections of the current New Jersey statute, revised statute 25:1-1 derived directly from the English Statute of Parliament 1677, passed by Charles II, the same one who passed the Tenures and Abolition Act in 1660. All right? The same statute you see in 46:3-1, 2, 3, 4, 5, 6, all the way up to 13. All right? You see it. These 5 sections are those which require most transactions in land or interest in land. It didn't say equitable interest to be in writing. All right? So revised statute 25 in this section deal with legal interest, not equitable interest in land. Why? Because the conveyance of land is not going back to the ceremonial process for conveying land, which is livery and seisin. They're going to take this out. The language of these sections, taken verbatim from the English Statute of 1794, has been retained virtually intact through several complete revisions of New Jersey statutes. Let's move forward. The New Jersey statute is in need of an in-depth revision. This is their presumption, that it needs an in-depth revision because they're saying that not only is it confusing to read, but it's not transparent. It said the first 5 sections that they re-amended through the five sections of New Jersey statutes from 1794 came from the original statutes that were passed by Parliament. And they saying the reason why they amended the statutes of Parliament, that they were confusing to read and that they were not transparent. And that they said as a result of this transparency, as well as the reading, and that can only come from the case law, because it said that the statute has been interpreted in large bodies of case law that has so changed the meaning of the statute of frauds that was established by Parliament in 1677. It has been interpreted in a large body of case changed the laws and the meaning of the statute as to render the literal language of some sections as being what, y'all? Deceptive. You hear that? Deceptive. In almost 200 years since the adoption of the statute of frauds in this state, not talking about any other state, this state of New Jersey, as well as in other jurisdictions, both the wisdom and efficiency of some of the provisions of the statute has been debated extensively. It is appropriate, not just in this case as on this platform, but definitely on April 16th when we go to court. It is appropriate under the circumstances to examine the policy reasons underlying the original provisions and determine whether and to what extent these policy reasons remain valid today. Do you see how your king is dropping it, y'all? Do you see how I'm dropping it? Now, the public defender, nor the prosecutor, nor the judge is fluent like your king is, all right? Nor are any of your leaders who are out there claiming to understand what it is in regards to reclaiming the land that was left in a trust for you. You call it CESUK, we call it Intel, all right? We call it intel. Commission has deliberately avoided the use of the term statute of fraud by way of underlying the fact that limited opportunities for fraud is only one policy that may serve by imposing a written requirement. In addition, the Commission considered intensively whether the approach of the existing statute, a preclusive writing requirement, was the best method of achieving the policy goals that were identified, or whether the identical policy goals would be better served by imposing higher standards of proof of transactions not reduced to writing. So that means that they wanted to make it efficient in regards to the conveyance of land, whether they were in writing or any other form of conveyance prior to those established in writing, by way of creating what we call the recorders of deeds or the registers of deeds, in regards to making sure that if there are any conveyance, that they be in writing as a result of the illegitimacy of the conveyances that were done by those who actually didn't own the land, by way of what we as we know as being de facto rulers. So they passed laws as de facto rulers, so that when the de jure ruler came to age, do what we call Inquisition post mortem, and do what we call livery of possession, the state can revert back like it was supposed to that ancient ceremony that we call livery and seisin. All right. How many of y'all heard that word, livery and seisin? All right. We're going to talk about it. Greetings, Countess Serti. This is a good one for you, Countess. All this is going to be talking about April 1st. That was the day the statutes of frauds were created. Did y'all hear me? We go to court on April 16th. April 16th. Look at it, y'all. Look at your king. What day was that passed, y'all? April 16th, 1677. That's the day we go to court, the English people. All right? In regards to the presumption that I violated the statutes of frauds. Okay? I couldn't violate the statutes of frauds because it was our ancestors who passed the act. Okay? It was them who passed the act. Let's see. Also, mind you, you see here, all right. Oh, you ain't seen nothing, Countess Serti. Real property under the statutes of frauds passed by Charles II. Section 1 provides that all leases, estates, and interests in freehold or copyhold or whatever type of physical that you have, all right, or the terms of years created by livery of seisin or parole not in writing signed by the maker shall have the effect as an estate of lease as at will. Section 2, then you got Section 3. All right. Section 3 provides that all leases, estates, and the interest of freehold or terms of years assigned, granted, or surrendered must be by deed or note in writing signed by the grantor or his agent or by operation of law. This is called the statute of dispensation. There must be a statute in place for the ability to be able to convey property, as we see in Title 46, colon 7-5 of the Judges by statute. All right. That's in our charter or our certificate of incorporation, which we call our charter, to convey property as our ancestors did in the time of memorial when the corporation so existed under those monarchs, all right, who personify the crown as I'm doing in this present day. All right. Let's get there. All right. So we must understand that the statutes of fraud protects the owner's equitable interest in property and not the legal interest in property, because legal interest in property is only based off the commercial aspect that the United States adopted by way of making fee simple equivalent to allodial, because they claiming they have allodial authority over the land through their prescription of sovereignty, through acquisition of sovereignty, which is nothing more than an easement, a non-possessory use and property that they do not own. Okay? That they do not own. Let's go back to the New Jersey Law Commission to validate this. Land provisions of the statutes of frauds. All right? Page 3. This is on page 3, y'all. Y'all about to learn something today. Let me warm my coffee back up. If y'all claim to be English heirs and successors, and y'all watching this video, y'all better be listening to me, not me, but what's being brought before you. Because if you don't know this, like I'm kicking it, you're going to have a problem. You could be my archbishop. You can be my moderators. You can be whoever you claim to be. Because you must be about my Father's business. You must be about my Father's business. I'm showing you our business. The business is church business. Church business is the body of policies that the church was founded on. All right? And that's God's law. All right? The law governing the land from fraudulent people operating on the land of the gods, who were called lords in those days. And the lords gave out fiefdoms to what we call tenants in chief. These are what you call those Native Americans. All right? Chiefs of those so-called tribes. We must understand, I'm about to drop it. Everybody pull that up. Land provision of the statute of frauds. Let me warm my coffee up and we can build. So once again, anybody got access to any platform? I don't care who they is. If they're searching for the truth, we need to be heard. Okay? We need to be heard. Nowhere. We reading it. It's New Jersey. Nowhere are the English origins of American legal system more apparent than in the law of real property. Both our statutes and judicial decisions on the subject are founded in the concept that were established in England over 5 centuries prior to 1776. Did y'all hear that? (1776). Imagine the look on the prosecutor's face from the public defenders hitting with this, because they don't know this. They got to be retaught all over again. They be like, Your Honor, I don't know if you guys are aware of this, but under the land provisions as qualified by the Parliament under King Charles II, which we recognize as part of our American legal system, as established by the New Jersey Law Commission, which is one who takes a look at the laws that are stipulated by statute. They clearly say that nowhere are the English origins of the American legal system more apparent than in the law of property. All right? Very important. Both our statute and judicial decisions on the subject are founded in the concepts that were established in England over 5 centuries prior to 1776. And when we say England, they're specific about who in England? Who? Oh, they're going to go into it later. I'm ahead of myself. Okay. Both nowhere in English origin of American legal system We're talking about their whole legal system. All right. The foundation of the legal system is rooted in Anglo-Saxon jurisprudence. All right, which is not limited to any constitution, legislative parliament. It was enacted as what we call use. All right, time out of mind. It was just being practiced. All right, it didn't become written down till it became subject to infiltration or dilution. All right, when they tried to dilute it or make it other than what it really meant, as we see, as they stated in the case law, that the statutes of frauds were being used in case law as a deceptive practice to take it from the original meaning for which it's derived from. Okay. Nowhere in English origin of American legal system were apparent than in the law of property. Both our statutes and decisions on the subject are founded in the concepts that were established in England over 5 centuries prior to 1776. In particular, the codified laws of this state still incorporate centuries-old English statutes that establish fundamental properties of law principles. Revised Statute 46:3-5, Statute of Queen of Pretoris, Terem, Revised Statute 46:3-9, the Statute of Uses, and another statute in the New Jersey Statutes of Fraud, which is the first 5 sections, which is New Jersey Revised Statute 25:1-1-5, are derived from the English Statute of Fraud of 1677. There you see it again, right? There you see it. Right here, y'all. Because the writing's requirements for land transaction is so fundamental to our present-day conveyance system, it can be difficult to imagine. This is New Jersey's talking, y'all. These are those who sit in the committee and review legislation passed by the commission. All right, the board of commission, because it's not a government. The state corporation is ran by a board of commission, and a law review commission reviews the laws passed by the board of commission. All right, I hope that makes sense to everybody. All right. Because the writing requirements for land transaction is so fundamental to our present-day conveyance system, it can be difficult to imagine a time when it was otherwise. So they're saying that the conveyance system of how land transactions are done is very important to them, and to have it otherwise will be difficult in the time imagined when people were ignorant about these processes in regards to land transactions. All right? Because what they're going to say is in England, prior to the statute of frauds, however, the transfer of land by seisin, in England, prior to the statute of fraud, however, transfer of land by ceremony rather than by writing was still valid. All right? You hear that? So there's a difference. Ceremonial conveyance of land versus or contrast to writings that denote to conveyance of land, such as what we call a deed. All right? These are two processes that we need to consider. So, and let's read it again. Because the writing requirement for land transaction is so fundamental to our present-day conveyance system, it is difficult to imagine a time when it was not otherwise. So the writing system that's required to the modern-day conveyance of land is so important, and to not understand that importance prior to how it was conveyed will be, as they said, problematic. Why is it problematic? Because prior to their recording system, these people were illiterate on how land was conveyed, let alone how it was recorded. All right? How it was recorded. In England, prior to the statute of fraud, however, transfer of land by ceremony rather than by writing was still valid. The method of conveyance livery of season derived from feudal concepts of landholding. While this method was workable, when most of the population was illiterate and ownership of land was a matter of common knowledge in community, in the 17th century, this type of conveyance had largely been superseded by more modern written forms of conveyancing, and then the old forms increasingly were parts of. Let me read that again. While this method was workable when most of the population was illiterate in ownership of land, it was a matter of common knowledge in communities. So people were illiterate, but land ownership was a common knowledge to people who own property. So in order for you to own property, you had to have the common knowledge of property. And if you were illiterate, then you didn't have that common knowledge. All right. It says in the 17th century, this type of conveyance had largely been superseded by more written forms of conveyances, and the old forms increasingly were used when a secret conveyance was wanted for illicit purposes. You hear that? So livery and seizin was done for illicit purposes, and we're going to see that as what's committed by what we know as William Penn and the whole state of Delaware. That whole state of Delaware was created by way of livery and seizin, which was an ancient way, a ceremonial way, how we conveyed land because of the ceremonial criteria, which we'll discuss in a second. All right? The lawmakers of the day came to recognize that ceremonial conveyance of land facilitated tax evasion and fraudulent transfer of land and made litigation over title to land more difficult to resolve. The statute of frauds changed conveyancing practice in England by expressly eliminating conveyances of land by livery of season and by requiring conveyances of land to be in writing, i.e. deeds. Okay? Filed in the recorder of deeds or the register of deeds to prove that one has interest in the property that they now are in possession in by way of what we call easement, because they don't own it, because the register office or the county recorder's office for recording property was only recorded for the purpose of giving it to the other individuals other than the owner, as we read in the definition. All right? So they're saying that under the statute of livery, which was the original or ceremonial way of conveying property, it was used for illicit purposes. All right? This is what New Jersey said. Law Commission said. All right? This is what they said, because they understood, or they must have understood, the origin of where livery and seizin came from. If they assume or presume that under that method that practices were and the conveyances were being done for secret conveyances and illicit purposes. That's what they're saying. Everybody understand that, right? We see that. So we just can't read stuff and not break it down and put ourselves in the position of these people, because that's what we need to put ourselves in the equation. All right? So it says, as a result of the secret conveyances that were done for illicit purposes, they created the statute of frauds in 1677 that all wills, grants, contracts, deeds be in writing in lieu of the conveyances, to show that the actual conveyances was a lawful conveyances prior to the normal conveyances that goes back to time immemorial, dealing with the ceremonial that they recognize, as we see in New Jersey Law Commission. So what is the ceremonial proper way of conveying land? First, we're going to watch a video on it, and then we're going to talk about it in our own measure, okay? We're going to talk about it in our own measure. So let's see how those who are using it for secret conveyances and illicit purposes are doing it by way of the process of common recovery, which turned Intel estate into fee simple, and now fee simple are being substituted for free and common soakers and are being put on the equal footing and an equitable footing with allodial. And we know that is a clear lie. We're going to prove it. All right? Your king is going to prove it beyond a shadow of doubt. Not just out here on this platform, and I can do it in the world, but I'm going to do it in the courtroom on April 6th, because it all involves April 16th, because it all involves the presumption of fraud in violation of the fraud, because the purpose of why these were created to commit fraud and perjury upon the original creditor. All right? Let's see. Let's watch the video. Everybody ready? Everybody, please pay very close attention. Very close attention. Michael Robinson, this is an attorney or lawyer, all right? Who you see the handshake, right? See the handshake, right? Now watch the language. Who else will provide this for their people? Who else would do such a thing? All right, we got to ask ourselves that. I'm taking a risk to provide you with this information that you are ignorant of. All right? You shouldn't have been. The only person that are literate in it is those who took it from us. All right? And then put in this process, which based upon our ignorance, maintains the status quo. We see that through Frederick Douglass. Frederick Douglass, because he was the first recorder of deeds. All right? And he was Anglo-Saxon. He was put there as a flag. All right? As a beacon light. To let you know that on our crusade back home, he's pointing go back this way. The crossroads. All right? Let's get there. I'm going to warm my coffee up because I don't want to miss this player. So everybody hold on for a second. Here we go. Strap on your bootstraps, y'all. Let's hear it.
We had in a previous segment, we were talking about deeds, the different types of deeds. We went through standard 6, but
Can everybody hear that?
Because most people were
let me know, my moderators, if you can hear that. Okay, I got you. I got you. Thank you, County Searching. Okay, let's see. Hope it won't flag us. here we go.
Today we're talking with Michael Robinson from Robinson and Henry Law Practitioners. Michael, welcome to the show. Thanks for being with us. We had you on a previous segment. We were talking about deeds and the different types of deeds. We went through the standard 6, but at the end we started talking about a very old method in which they used to transfer property, and it was called livery of seisin.
Can you hear that?
Sure is, and that's where the deed actually comes from, is that action. All right, real quick, what is livery of seisin recap? Okay, because most people were illiterate in England at the time this.
Okay. Okay, now we just heard it in New Jersey Law Commission. He said at the time of livery and seisin that the people were illiterate, but livery and seisin was a common knowledge to those who understood that process of that conveyance of livery and seisin and the intent of why it was conveyed in that way. All right? So we must understand that New Jersey is very well aware of this process, and attorneys are going to prove it because these are attorneys talking. All right, so let me play before they flag it.
Today we're talking with Michael Robinson from Robinson and Henry Law Practitioners. Michael, welcome to the show. Thanks for being with us. We had you on a previous segment. We were talking about deeds and the different types of deeds. We went through the standard 6, but at the end we started talking about a very old method in which they used to transfer property, and it was called livery of seisin. Is that correct? Sure is, and that's where the word deed actually comes from, is that action. All right, real quick, what is livery of seisin recap? Okay, because most people were illiterate in England at the time this thing developed, they would bring witnesses out to the property, and witnesses would be able to witness the buyer giving money, the seller giving over the actual physical parts of the property, namely turf and twig, which is the two things that it's called turf and twig ceremony. All right, so for first time ever on Broker IP TV, we'll do a reenactment here. I think it's excellent. Right. So what we're going to do is we're in Old England, and we're going to transfer property. And, of course, we have to dress the part. Now, am I the buyer or the seller? You are the buyer. And you're selling me this land? Yes, and we've come out here with 2 witnesses. Okay. Watch all this happen. And how does this procedure go? Okay. You're going to start by cutting out a piece of turf on the property. All right, so we'll just... and you hold on to that turf. I hold on the turf. Now, put money in the hole. All right, got some cash. How about a buck for this? Buck is worth here. It's a couple shillings back in Old England. Okay. Okay. And then hand me the sod. This piece? Yes, you did. Okay. And I take the twig. Yes. And I take the sod, and I say this following: this turf and twig I give to thee, as free as Athelstan gave to me, and I hope a loving brother thou wilt be. And I twiddle you with the twig. Really? Yes, I do. And then I put it in the sod and I hand it to you. Thank you. And then you take the sod and put it back in the hole. All right. And with that, you just bought this wonderful property. And I've been twiggled. Yes, you have. Wow. And the reason for that was so that blind people could still buy and sell property. They couldn't see what was going on. They knew that they were getting the twig, and they knew that they were getting the property. Well, that's a heck of a lot easier than the 3-hour closing today. Yeah. In Pennsylvania, the entire state of Pennsylvania was purchased exactly this way by William Penn. Really? Yes. And there's a statue of him in Delaware, actually, went just across the river from Pennsylvania, where he actually did this turf and twig ceremony. All right. Last but not least, could this be recorded? Yes, and that's actually what was happened was at a later time when we started moving more towards recording of deeds, they would get the witnesses and they would get them to sign an affidavit saying that they had done this particular thing and that they had witnessed that this happened. They witness an action, they witness a deed occurring. You did a deed, or I did a deed by giving it to you. And that's actually where the word deed comes from. And all the other deeds that we have today, and this thing, and most of this stuff, if you think about it, still exists today in modern real estate. When you go to a closing, there are other witnesses, one of which is the notary public. And almost always, when you go to a closing at the end, the buyer hands the keys to the seller. Well, I'm going to twiddle my buyer at my next closing. Michael, thanks so much for the information. I appreciate it.
All right. Hope y'all all understood the process of what's going on, all right? Because I'm not going to play it again. I want to get flagged, all right? I'm grateful they allowed me to show it that time, all right? So we understand the process of livery and seisin, and we know that that process was abandoned as a result of deceptive and illicit practices, all right? Okay. All right. So we see here. The conveyances that were done contrary to the old form were for illicit and secret conveyances. I'm not worried about if I did it, friends. Their laws don't mean nothing to us. All right? Because it's done for, as they said, secret conveyances for 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 illicit purposes. It's illicit purposes because they're conveying it fee simple. All right? They're conveying it fee simple. Thank you, Countess Searching. You know what I'm saying? And the fee simple has a fraudulent conveyance in regard to the origin of where it comes from, and that's why the statute of frauds was created. They're actually violating the statutes of frauds, and I'm going to show you in the case law that they're violating the statutes of fraud, but claiming to the remedy that are provided for us. All right, but they're not going to get it. All right, let's check it out. Let's go ahead. First of all, nowhere are the English origins of American legal system more apparent than in the law of real property. Both our statutes and judicial decisions of the subject are founded in the concepts that were established in England over 5 centuries prior to 1776. Codified in law, the states incorporated these century-old statutes that establish fundamental principles are property law principles. First being the statutes of Queen Imperatrice and the statutes of uses, all protected by the statute of fraud. Not how they recorded deeds in the present day by the county court of deeds, but how it was conveyed under what they say livery of seisin. All right? Livery of seisin is what statute of Queen Imperatrice and the statute of uses and the statutes of intel protect. All right? Which, if you don't know about it, then how can it protect you? All right? So let's go through that. Queen Imperatrice. Let's deal with the first one. All right? We see this statute as established by New Jersey Law Commission. It's in Title 46, 3-5 of the New Jersey Revised Statute in 2024, which will be in the birth year 2974. We see the statute of Queen Imperatrice, all right, in regards to how land was conveyed back in 1290, all right, King James them were not even independent from the sovereignty that was under the House of Plantagenet under Edward I, who gave Scotland their independence and the Scots independence of 1295. How many of you know that? You better know it when I take my place. You better, because I'm going to quiz you. Because I'm teaching you now. And the ones who's watching this lesson is going to be judged more strictly than the ones who not. Queen of Pretorius is a statute passed by the Parliament of England, not Ireland, not Scotland, but England. In 1290, during the reign of Edward I. Who was Edward I? Where is his house? The Plantagenet crown. Everybody see that? His father was Henry III. He was of the Plantagenet crown. You see ourselves. You see it back there. We are of the Plantagenet house, which was established by Godfrey the Fifth Caliban Jew, because my heraldic or livery descent of nobility goes back to Godfrey the Plantagenet. All right, son of folk, where folkland comes from. Yes, sir. Folkland comes from Godfrey the Fifth Caliban Jew, which William the Conqueror called the Doomsday Book, which is also called Bookland, right? Which you now call the County Recorders of Deeds, all right? Where all the land that was tenured out to the lords and their attendants in chief through Queen Imperatrice was recorded instead of being sold off under the process of fee simple, all right? Which we can prove that that's what they're doing, because they said they made fee simple equal with free and common soakage and equivalent with allodial and substituted for free and common soakage. All right. So that is a straight fraudulent act of Parliament that passed the law to protect it from acts such as the one that the state of New Jersey is committing. Why? Because your law commission, you recognize the laws that we're reading that go back to our customary laws that goes back to the time of 1290. Queen Imperatrice. Let's read it for ourselves. Queen Imperatrice is a statute passed by Parliament of England in 1290 during the reign of Edward I that prevented a tenant from alienating their lands to others by subinfeudation, instead requiring all tenants who wish to alienate their land to do so by substitution. We know that we just said New Jersey substituted the word fee simple for free and common soakage and made the word fee simple equivalent with allodial. Okay, so we see it here. Queen Victoria is a statute passed by Parliament of England in 1290 during the reign of Edward I that prevents tenants from alienating their land to others by subinfeudation, instead requiring all tenants who wish to alienate their land to do so by substitution, means put another person in place of the original tenant, or to take the place of, okay? To take on the same obligation that the original tenant did prior to the receiving the fee. All right. Instead, requiring all tenants who wish to alienate their land to do so by substitution. The statute, along with its companion status quo warranto, which means the order to show cause, also passed in 1290, was intended to remedy the land ownership disputes and consequent financial difficulties that have resulted from the decline of the traditional feudal system. You hear that? In England from the High Middle Ages. The name Queen Victoria derived from first two words of the statute in original medieval Latin, which can be translated as because of the buyer. Its long statute is the Lord's is the statute of our Lord King concerning the selling and buying the land. So the statute of Queen Victoria, so the statute of Westminster III, it's the statute of our Lord King concerning the buying and the selling of land. Did you hear that? Everybody needs to understand that. By effectively ending the practice of subinfeudation, everybody needs to know what subinfeudation is. In English law, subinfeudation is the practice by which tenants holding land under the king or other superior lord carved out new distinct tenures and their in turn by subletting or alienating a part of the land. That's what they're doing. They're subinfeudating, and subinfeudating do subrogation, and right of subrogation is the right to collect on behalf of the person who actually has the right to collect. So through subinfeudation, they had a right of subrogation based off the free and common soakers that actually belong to the king. All right. So in English common law, it is the practice by which the tenant holding land under the king or other superior lord carved out new and distinct tenures in their turn by subletting, i.e., leasing, i.e., landlord tenant, or alienating a part of their land. Okay, let's get an example of this. As we can see, estates and land, highest form of New Jersey real estate book is fee simple estates, fee determinable, and life estates. All right. These are subject to reversionary interest or by way of remandment. All right. Once again, life estates, fee determinable, and fee simple. And we know fee simple is subject to encumbrances such as tax. All right. So it's not the highest form of allodial. All right. But yet they trying to say in the New Jersey Law Commission that fee simple is equivalent to allodial, which we're going to prove them wrong, and that they substitute the fee simple for free and common soakers. How you going to do that and take when the crown is the right for owner of all debts owned by any debtor in lieu of the creditor, which is the crown, who created the position for you to be as a grantee. All right? He created that position. Let's look at it. Person dies, escheats, state of New Jersey takes the property as a result of its escheats, as a result of them being no heirs. All right? And if there was heirs, then that means that the land will be held under the entail estate. All right? And not fee simple. Because entail estate belongs to crown land, and our crown land is entail. If there is no feudal tenure in lieu of entail estate, then the land will automatically escheat to the crown. All right? See, I understand this. This is what y'all have to understand in order to make it into the kingdom. All right? Or else you'll be doing exactly what's been going on. That's why I'm revealing to you now. All right? So if you're not listening, that means that you're guilty as charged. All right? Person dies, interstate, no heirs. The land is streets, property is streets, whether real or personal property, to the state of New Jersey through the eminent domain power through what we call acquisition of sovereignty by right of discovery or right of conquest. All right? They take it through what they call eminent domain power of the state for public use, but they must compensate you. All right? What did they give you? All right, it wasn't based off. They so-called gave you a fraudulent loan. You're supposed to be paid from the door as they was under the process of the ceremonial process through Livery of seisin. Whereas though when you picked out that sod and you conveyed it to the actual purchaser, they put that shilling in that hole. All right, and then that twig is put in that sod or that turf, and then that shows the actual conveyance through what we call livery of season by way of two ways, through livery of deed or livery of law, which we'll discuss in a second. All right? Everybody catching up? Everybody following? Right to Queen of Pretorius. The statute of our Lord King concerning buying and selling of property. Background. All right? This is the background. Prior to the Norman conquest of England in 1066, the Anglo-Saxon law of land succession was customary. Did you hear that? So if it's customary, that means it was ceremonial. All right? We're going to prove it. Sorry about that. Catching the cold. Prior to the Norman conquest of England, 1066, under the feudal age, Anglo-Saxon law of land succession was customary ceremonial land or folk land or book land as it was called, and it was held in a allodial title by the group by way of the feudal tenure estates granted by the crown by way of free and common soakage, meaning that the group held the land. It was probably a little relevance with the titular head of the clan or family died. Traditional lands continue to be held in communities by the group. The exact nature of the allodialism as it exists in Anglo-England has been debated, but no definitive end. On one side, it has been argued that in the Mark system, Saxon allodialism was highly idealistic, socialist, communitarian state. Let's move further for some more concrete. After the Norman conquest, the rule became one of primogeniture inheritance, meaning the eldest surviving son became the sole heir of the baronial state. The intent of the primogeniture inheritance was to keep the large land holding in the hands of a relatively few trustworthy lords. The other sons could be accommodated by becoming underlords to surviving heirs. The elders would accept the younger brother in homage in return for their allegiance. Everybody hear this? Let's move forward. In English law, after the conquest, the lord remained a grantor after the grant of an estate in fee simple. All right? There was no land in England without a lord. Nulla terra sun sequenere was the feudal maxim. These grants were in turn subject to subinfeudation. You hear that? That's not the ancient practice, how the Anglo-Saxon did it. The principal instance of a seigneury was an oath of fealty, i.e. pledge, a quiet or chief rent, a relief of one's rent, prior rent, and the right of a sheep. All right? In return for this privilege, the lord was liable to forfeit his right if he neglected to protect and defend the tenant or did anything injurious to the feudal relation. The word fee is associated with the Norman feudal system and is contradiction to the Anglo-Saxon allodial system. Did you hear that? That's qualification for y'all. Hold that thought. So don't get it twisted. We're totally different from what William the Conqueror did through the prescription through acquisition of sovereignty, which the colonies adopted through their legislative enactments that was borrowed from the Parliament of Great Britain. All right? At the time of the conquest, William the Conqueror granted fiefs to his lords in the manner of continental or feudal benefits, which are assured little beyond a life tenure, life estates. Okay, you hear that? So William the Conqueror recognized that he was subject to the laws that were already in place based off the conveyance of property out that was subject to what we call the ceremonial or what they call customary methods. Magna Carta and Great Charter of 1217. The Magna Carta of 1215 gave little mention of the rights of alienation. It contains 60 chapters and represents the extreme form of baronial demands. John managed to receive a bull from Pope Innocent III annulling the Magna Carta. The Magna Carta was effective law for about 9 weeks. King John of England, the son of Henry II, son of Godfrey, fifth kind of Grand Jew, died shortly after 1216, i.e., that's when the Parliament of England was established. The council will rule in the name of his infant Henry III of England reissued the charter in 1216, this time with papal assent, and it was very much modified in favor of the crown. Everybody, are y'all listening to what I'm telling y'all? For it. Okay. So Queen and Pretorius, you cannot alienate land, but you can only substitute it. All right? Substitute tenant in place of another tenant that was subject to the Lord, and he took on the same responsibility to that Lord in lieu of that homage that he were paying in lieu of the free and common soakers that the Lord owed to the king. Okay? That's how things were done. All right? It became common practice to subjugate to the younger son. There are cases from the time in which a writ of the courts was granted demanding that the eldest inherit the son by force to accept in homage the younger sons as a way to enforce their subjugation, as there had been no survey of land titles since the Doomsday Book over 200 years earlier. They just said 20 years, and the Law Review Commission. What was that at? – 20 years. You hear that? 20 years. So it said, since Doomsday Book, over 20 years, outright title to land had become seriously cloud on the title, in many cases, as was often in dispute. The whole feudal structure was a patchwork of smaller landholders, although the history of the major landholder lords is fairly well recorded. The nature of the smaller landholders has been difficult to reconstruct. Some directions toward order had been laid down in the Magna Carta. The provisions of Oxford and the scanty legislation of Simon de Montfort, Earl of Leicestershire, ever the first set about to rationalize and modernize the law during his 35-year reign. The first period from 1272 to 1290 consisted with the enactments of Statute of Westminster of 1275, the Statute of Gloucester of 1278, the incorporation of recently conquered Wales into the Rim. They were followed by the Statute called Warranto and the Statute of Mortem. The latter was designed to stop the increasing amount of land which were ending up in church ownership, i.e. they're talking about the Church of England. The Statute of Westminster 1285 contained the clause of de donis conditionibus, which shaped the system of entail in the state. The Statute of Westminster was passed in 1285. This was followed by Queen of Pretorius 1290, which was only about 500 words in length. Did everybody hear that? So this is all the stored, preserved antiquity laws preserved to ignite and emanate and shine and resonate with you when you recognize who you were. All right? That's what your king is telling you. You have all this power. The donors condition the bus. What is the donors condition the bus? Make sure I cover everything. Yeah. The donors condition the bus. The donors condition bus was passed in 1285, which is the English Statute of Westminster. It originated the law of entail forbidding a landowner to sell his land except to an heir. Did y'all hear that? Did y'all hear that? Except to an heir. All right? So I must be an heir. All right? I must be an heir if I'm doing exactly what the legislature of our ancestors that were put in place by de facto monarchs to uh, 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 preserve in regards to that one individual under the allodial title, do what we call Inquisition post mortem, to take it through livery of seisin by that one heir. All right, which was the proper form of conveying land based off the ceremonial or the conventional way, which was customary to us. All right, which was customary to us. Let's prove that. Statutes of Uses, passed by Henry VIII. Statute of Uses, because remember, a non-possessory use is an easement, all right, by prescription, through acquisition of sovereignty, through prescription of sovereignty, which resulted and manifested through the time of the War of the Roses, as we see in what we call Queen Imperatoris. Let's revisit that right quick. Right here. Queen Imperatoris, it is thought by historians, let me make sure y'all see that. It is thought by historians such as Charles Plummer that this then developed into one of the possible underlying causes of the War of the Roses. Other sources indicate the essence of a bastard feudalism as early as the 11th century in the form of livery and maintenance, okay? Not livery of seisin. So what is livery of seisin? Because as they stated in the video, that the former ceremonial way of conveying land, based off the language that was conveyed in the video, which we address in a second, in regards to the illicit and the secrets conveyances that were done by the lawyers that you see in this video, as result of the so-called understanding of the colorable definition for fee simple, such as free and common soakage and allodialism. All right? Which has nothing to do with the common recovery process that's being done by those who are now in the position to be brought before the court based off the court warrant that's going to be presented on behalf of the English people by your king, King Clifford Jefferson. Because it said Queen Imperatoris' companion was a court warrant, which means an order to show just cause. Right? That's the position of a defendant. Right? That's the position of a defendant. All right? Because if somebody's doing something other than what they should be doing and impose that down somebody else, then that means that they're playing a position as the sole power. That means you become the subject. That means that You're subject to that power, which makes you the beneficiary of that subjectivity. All right, and that subjectivity is not how the beneficiary process is supposed to work. All right, it's stalling the beneficiary process that was created for the transition of the estates. All right, let's qualify this, y'all. Let's really bring it home. All right, where we at? Livery of Caesar. Livery of Caesar in a archaic legal conveyance ceremony formerly practiced in feudal England and other countries following the English common law used to convey holdings and property. Did you hear that? Livery of Caesar is an archaic legal conveyance ceremony formerly practiced in feudal England and other countries following English common law, used to convey holdings and property. The term livery is close to and is synonymous with delivery, used in some jurisdictions in contract law or related laws dealing with deed. All right, as we can see in the law commission that was presented before you. All right, from property as well as dealing with the statutes of fraud. The oldest form of common law provided that a valid conveyance of feudal tenure and land requires physical transfer by the transferor to the transferee and the presence of a witness. This will be a notary, all right, of republic, notary public, of a piece of the ground itself in the literal sense of a hand-to-hand passing of the amount of soil of twig key to a building on that land or other token as conveyed in the video. But it must be based off the ability to be able to having the right to convey land, based off you being the heir and by way of substitute, and not by subjugation as a result of subrogation by way of what we call subrogation. All right, very important that you understand that. All right, so that's why we must understand what are the varieties of ways that delivery of possession of an estate and land lawfully can be done. All right. No king is bad. Library of Caesar could refer to either library of deed, all right, so we're not talking about the deeds filed in the county recorders or the county register, all right, by way of the statutes of frauds that were passed by Parliament in 1677. We're going back to the original customary and ceremonial archaic form of conveying land that was under the allodial authority of the king, all right? And when the land was allowed to be tinkered out, it was based off the laws passed by the Plantagenet kings through what we call the Donus Conditionalibus and the statutes of Queen Pretorius, all right, which were mentioned a second ago. All right, let's go. Library of Caesar could refer to either library indeed, whether the parties met together on the land and transfer symbolically deliver possession of the land by handing over a twig or a clump of earth to the recipient, as you see displayed in the video. Delivery in law, whereby the parties went within sight of the land and the transfer declared to the recipient that possession was being given, followed by the recipient entering onto the land. All right? The symbol of library for a house was the door ring or hasp for mills, the clap of a hopper for a church, a psalmbook and key, and so on and so on and so on and so on. This we call it a library badge. All right? We'll get into that in other classes. All right? The turf and twig ceremony dates from the feudal era, but was used regularly in the colonial America, allowing the English and Scottish, after the Treaty of Union, termed the British by virtue of their monarchs' claims to take sovereign possessions over unclaimed lands. The process has taken several forms over the century. There's your proof. All right? We know in United States versus Lee that the prerogative of the crown was severed because the crown wasn't operating under the demise like it's supposed to be by the transfer from one king to the next. It was an interregnum, and the interregnum resulted because of the English Civil War, which resulted in the War of the Three Kingdoms, which started with Oliver Cromwell, which ended in the Treaty of Westminster, which ended with the restoration of the crown. All right? We talked about that earlier today. I'm not going to go back to it. All right. So we see William Penn used the same process to claim abandoned lands or vacant lands through the process of acquisition of sovereignty by way of the conveyance, by way of what was his name? John, what's his name? What was his name? Ephraim Herman and John Moore, which were the attorneys for who conveyed the land to William Penn that we're talking about in lieu of the turf and twig ceremony. All right, he conveyed the land to William Penn, and this can be reviewed in New Jersey versus Delaware. All right, New Jersey versus Delaware case. Why it talks about it. All right. It says that Charles II was a de facto monarch and that his claims were void. You see that in New Jersey revised statute, Title 46, colon 3-1 and 2. Tenure, Finger about, what is it? Tenure Abolition Act, 1660, Charles II. So whatever William Penn was doing was unlawful from the door. Can I get anyone of my moderators to co-sign that if you out there? All right. So dealing with livery season through the twig and turf ceremony, all right? We know that a commoner under the Commonwealth was not an heir. Okay. It was void, okay? We're about to read it. We're going to see why it was void, all right? Let's read it for ourselves. Bernard Hodge, in the history of Malmesbury, described the process in at least Wiltshire to continue in the late 17th century as follows. The lucky newcomer goes to the lucky new commoner. We know a commoner is not a man of nobility, all right? Not a noble, not a royalty. A commoner, also known as a common man, commoner, the common people, or the masses, was an early use in ordinary person in community or nation who did not have a significant social status, especially a member of neither royalty, nobility, nor a part of the aristocracy. All right? Do y'all hear what I'm telling y'all? All right? You see the template of the past few videos that deal with the aristocracy. All right? The two videos I showed you. All right? You have to understand what you're really dealing with. All right? The lucky commoner, which you are the lucky commoners, all right? If you're not part of the Anglo-Saxon ancestry or you're not part of the English Third Temple Church of England, all right? It says the lucky new commoner goes to and give acres and cuts a turf from the selected site and drop 2 shillings in the hole shillings in the hole that's made. Did anybody drop a shilling in the hole when you were conveyed the property? No. You got a contract out there that pledges to pay for something that they ain't worth nothing because money is not considered a medium of exchange under the contract clause, Article 1, Section 10. All right? A shilling does meet that requirement. All right. The high steward of the county then twitches him with a twig and stick, the twig in the turf, points out. It says the high steward of the county then twitches him with a twig and stick, the twig in the turf, then hands it to him, saying, This turf and twig I give to thee, as free as Athelstan gave to me, and I hope a loving brother thou wilt be. The high steward then takes the money, i.e., lawful money, out of the hole, and the landowner replaces the turf, meaning he puts back in place, whether it was done by livery of deed or livery of law. All right? And this process goes all the way back to the customary or ceremonial processes that were in place prior to the creation of Recorder of Deeds, which was created by the Statute of Frauds under what we call Statute of Frauds Act of 1660, because we know that all those deeds originated from Livery of Seisin, which we're reading now. All right, and the ceremonial requirement for the conveyance under the ceremonial procedure was based upon that, which goes back to the time of Athelstan. If anyone of y'all know who Athelstan is, let's see. Look at that, y'all. Look at those faces. They were a darker complexion, Anglo-Saxon Berbers. Athelstan, noble stone, was king of the Anglo-Saxons from 924 to 927, and king of the English from 927 to his death in 939. He was the son of King Edward the Elder, his wife Evelyn. Modern stories regard him as the first king of England, one of the greatest Anglo-Saxon kings. Did y'all hear that? Are you following what I'm saying to y'all? All right? That's the ceremonial process that land was conveyed from the time of our ancestors up to the time that it was abolished by New Jersey in their law commission, all right, as established for the record on the record, all right? Inquisition post-mortem. Everybody better listen. What was your question, Counter Searchy? Inquisition post-mortem library of Seisin. Under the feudal system, all land belonged to the monarch and was therefore either held by him directly under his royal demise, jure regalia, all right, or on the behalf directly or on his behalf directly or indirectly. Those who held land directly on the king's behalf were known as tenants in chiefs. When a tenant in chief died without an heir, his land is ceded to fell into the hands of the king. If there was an heir, the king kept the land until a livery of Seisin took place. The heir paid a sum of money, a relief, to take lawful or assume possession of the land. Okay. I got you. Edward and Athelstan are not the same. There was an Edward the Confessor who descended down from Athelstan, but the only Edward after that is the ones who succeeded him. All right, but Athelstan was the son of Alfred the Great, which means Alfred the Great means wise elf, and Athelstan means noble stone. Okay, they were considered athelings. Atheling is a noble name that denotes to Etheling. All right, Etheling. All right. If an heir was under the age under the Livery of Seisin, the king kept the land until he or she came of the age. 21 for men and 14 for women. And the king received rights of wardship and marriages, collecting the revenues of the estate and disposing of her in marriage. he was able to sell those rights to third parties who were not necessarily the ward's next of kin. These are called abstract titles. These feudal tenures and rights were abolished in the interregnum, reintroduced, and then abolished in the following period of government at the reign of Charles II in 1660 and 1685. That goes back to the Tenured Abolition Act. 1660. We're talking about Livery and seisin, and it said this practice was abolished at the time of Charles II under the 1660 to 1685. All right, that was under the Commonwealth. All right, let's go back to the Tenured Abolition Act. Right there. These are unchallengeable facts that I'm giving you. All right. Facts. You can't disqualify. All right. So let's get there, y'all. All right. So we know until Livery and seisin cannot take place until that heir is conscious of the right to take possession of the intel estate that was left based off what we call Inquisition post-mortem. All right? Inquisition post-mortem. That's through seisin. What is seisin? Let's review that real quick. Everybody pay attention. Seisin. Seisin denotes the legal possession of a feudal fiefdom or fee, that is to say, an estate and land. It was used in the form of a son and heir of X has obtained possession of his inheritance, and thus is effectively a term concerned with conveyancing in feudal era. The person holding such estate is said to be seized of it, a phrase which commonly appears in Inquisition post-mortem. The monarch alone held all land of England by his allodial right, and all his subjects were merely his tenants under various contracts of feudal tenure. Did y'all read that? Did y'all hear that? Did y'all understand that? All right? I hope y'all did. I hope y'all did. All right? Because if you didn't, you're going to find yourself in the same position of this individual we're about to discuss right now in closing. All right? George, in closing, George A. Gallatin III versus Borough of Paulsboro, all right, a municipality, all right, in the state of New Jersey, filed a complaint on the Superior Court of New Jersey, which he had to appeal in the appellate court as a result of the eminent domain power that was being done by the municipality in regards to the eminent domain power to take private property without just compensation. All right. And the appellate court ruled against him, which he was obligated to seek remedy in the Supreme Court. All right. So everybody can pull this case up. George A. Gallatin III versus Borough of Paulsboro. This case was heard in Superior Court of New Jersey, Appellate Division docket number A-3295-16T3. All right. George A. Plaintiff, the third plaintiff and appellate, who owned the property in fee simple absolute. Okay. The property that he owned was in fee simple absolute. all right? And the state municipality under the municipal charter, under the eminent domain power that was given to them under the statute, was allowed to have a higher equitable legal interest in the property as a result of fee simple, because we know fee simple has encumbrances, all right? The public land use, they took it as a result of it being subject to what we call Land Privacy Land Act, something like that. We'll discuss that in a second, all right? But this case was filed in Superior Court of New Jersey Appellate Division, all right, in 2018, not that far off, all right? Argued May 30, 2018, decided June 26, 2018 before Judge Gilson and Judge Meyer, all right? Everybody see that? All right, let's go ahead. Supreme Court. This is his petition for writ of certiorari or petition for certification. All right, we're gonna close out on this. I think I held y'all long enough. George Gallatin III, Esquire. So he's an attorney. All right. So in the Bureau of Plawsboro, all right, the council, all right, the Board of Commissioners, on a petition to the Supreme Court of New Jersey. Did you hear that? He went to the Supreme Court of New Jersey. He won it in 2007. Then the case was filed in 2018, and another issue in regards to the eminent domain power of the state, and he lost. Okay? So therefore, he's forced to seek remedy in a court of review, or the highest court of review, which will be the Supreme Court of the United States, all right? Which they heard. I mean, I don't know if they heard it, because this petition was drawn up in 2019. All right, so it should be before the court. My concern is the argument that he raises. They were submitted Friday, March 2019. Okay? March 1st, 2019. So let's read his petition in light of what we already discussed today. All right? Fifth Amendment right against unjust violation of taking one's property without being compensated for it. All right? Take a property for public use under the eminent domain power or whatever state, body, party, whatever it was. It said, let's go a little further. Question presented. What protection do citizens of the United States enjoy under the Fifth Amendment just compensation requirement in conjunction with the 14th Amendment procedural due process requirement in matters of state action where personal owned real property is taken without any compensation whatsoever? Now, when we talk about this process, we're talking about the process that is done now and the process that evolved from what was back in our time, which was ceremonial and customary on the Livery of Seisin, which was based off the two methods. Because if it wasn't the two methods, then it is cheated to the premier seisin, all right, which was of the king. Let's go back there. I think that is. I see it there. don't see it. Second time we're gonna move forward. All right, where we at? Without any just compensation whatsoever. So the appellant is arguing that his Fifth Amendment right has been violated in lieu of the Fourth Amendment right to Fifth Amendment right to be property not be taken without just compensation, which is a violation of the 14th Amendment due process rights. All right, and this we're not going to review this case as a result of we pretty much know the end result of what's going to be in regards to the Supreme Court's decision, because this is just a petition drawn by an appellant. All right, this is drawn by the appellant. All right, so we want to look at the language that he used in regards to his relief from the decision made by excuse me, the appellate court of Superior Court of New Jersey. It says here, the petitioner is not a corporation. He's an esquire, but not acting in the capacity of an attorney, but he petitioning as a pro se litigant. All right? And under the presumption of as being a natural person, well, we know that can't be construed because the states or the United States definition of persons are legal persons and not a natural person. All right? Because if you were a natural person, you would have a nationality. All right? You would have a nation. You would have a government to protect your rights. All right? Like we as English people, English laws, English government. That's still in place right here. We're going to go down to page 15. In closing. Now look at the statutory laws that he's using. Same ones we just discussed. Codes and statutes and rules. District Court, Federal Statute, Title 29, United States Code, Section 1257A. He uses New Jersey Revised Statute, :46:3-5, which deals with Queen Imperatrice 18 with the first 1290. Now, he didn't put the statutes there, but we know because we know the New Jersey Revised Statute is actually parliamentary statute, which is 46:3-5. All right? New Jersey General Permanent Statute, Public Law, 1992. So he's making the distinction between the parliamentary statute and the revised statute that was incorporated in New Jersey State through the New Jersey State Law Commission, which is right here, 46:3-5. All right? That's also this, which we just discussed. All right? Which says that land cannot be alienated through subinfeudation, but it can be substituted by putting a new tenant in place with the same obligation that the prior tenant had in regards to that which was tenured by the landlord, which had an obligation to the king based off the grant that was given by the fiefman, which was the agreement or the contract. All right? You must understand this. All right. They even made exhibits. Title 46, new statute 46:3-1, because they know the impact that these statutes have. So he not only talked about the statute, he presented the statute as an exhibit. We have it incorporated in our religious society. So the evidence is the deed. As we know, under the video we seen, the witness was the notary of Republic. All right? He ain't got no Republic here in regards to livery of law, meaning that going to the territorial site and conveying it that way, other than the process of livery of deed, meaning going to that plot and digging out a sod or a turf, and then putting that twig in there and twig in the hand, showing the conveyance from the grantor to the grantee. All right. As a result of him having a lawful requirement to do so, being that it was subject to livery of seisin, which goes back to seisin dealing with that one person. All right, have the authority as the monarch through the process through what we call primogeniture to be able to act on behalf of the entail estate and deviate out to those who are heirs through entail estate, which is personified by the monarch in lieu of crown property, which is commonwealth whims, public land, federal land, which is we call the cess du cre. All right. I'm not interested in none of the procedural jargon in regards to how a petition is set up, because this is pretty much what you're reviewing, how a petition for cert is filed. All right, this is actually the format. I actually filed this format myself. Oh, I'm past it. I'm bad. Oh, I'm sorry. Yeah, I did. Now he has a reason for why his petition should be granted. Reason for granting this writ. We know the writ is prerogative of the crown. All right, it's discretionary under the prerogatives that were created by statute by the Constitution. All right. The case involves a state court which has decided an important federal question in a way that conflicts with relevant decisions of the Supreme Court of the United States. They're talking about Chisholm versus Georgia. Most specifically, a federal question concerning unconstitutional taking without procedural due process and any compensation violating petitioner's sovereignty over his private real property. So he's saying he's sovereignty because, as we see, fee simple is equivalent to elodio. All right? Fee simple is equivalent to elodio based off how they see it. Because we know fee simple was substituted for free and common soakers, which he's trying to collect. Watch what happened. He uses Chisholm versus Georgia, which is one of the justices in Chisholm versus Georgia case. All right? Let me just read this part right here. Because we're going to close out with James Wilson, one of the founding fathers. Associate Justice of the Supreme Court of the United States, James Wilson, who left Scotland, you hear that? During the Highlands clearances, was particularly focused on fee simple absolute and real property as favored through Queen Imperatrix through Edward I in 1290. So this Scottish immigrant from the Highland clearances who immigrated here as a result of the Jacob Rising in Scotland took the position of claiming fee simple of states due to conveying process that were borrowed from the ceremonial processes of how fetal teens were actually given out under livery of seisin. All right, under Queen Imperatrix that goes back to 1290 through Edward the First, when Scottish were still uh, 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 what they call slaves of England. All right, they didn't get their independence till 1975. I mean, pardon, so 1295. That's why they got. That's when they got their independence from Edward the First. So if their independence came from Edward the First in 1295, and they're talking about Queen of Pretorius in 1290 passed by him, so that means that those events that happened in that 13th century were happening right here in North America. Yeah, Athelstan was the son of King Alfred the Great. I'm part of. Yeah, Alfred the Great, Athelstan. All right. So Justice James Wilson left Scotland. We know Scotland left everything in place by way of the Treaty of Paris of 1783, as well as the Declaration of Independence of 1776, July 4th. All right. It says here. Social justice being one of the only 6 signers of both of the 1776 United States Declaration of Independence and as the framer of the 1787 of the United States Constitution, conducted public discourses upon jurisprudence and political science contained therein lectures as professor of law, at which time he published on the history of property. In his first paragraph, Associate Justice Wilson defines a bundle of rights and property. Property is the right of the lawful right or lawful power which a person has to a thing. Of this right, there are 3 different degrees. The lowest degree of this right is a right merely to possess a thing, i.e., non-possessory right, or what we call prescription. All right. The next degree is this right is a right to possess and to use a thing. That's fee simple. All right. Fee simple is the highest form of absolute right that they assume to be allodial. Well, we know the highest form of allodial is that of the king. All right. So it says the next degree is a right to possess and to use a thing, and the next is the highest degree of this right is a right to possess, to use, and to dispose of a thing. All right. So that's allodial. All right. No one has attained allodial title. Why? Because it's the prerogative of the crown. And the king represents the crown. All right. What does it say? Okay, here we go. Didn't I say this? Hold on, I think I saved this. All right, we're going to start here. And now provided herein are the reasons for granting the writ of simultaneously both argued by original intent of the framers of the United States Constitution and the living Constitution case law analysis. All right, I'm only going to go to the most important points. I think I had a highlight. Let me just make sure. 2019. I have to say. Okay, here we go. All right. Okay. Now he's quoting James Wilson. All right. We'll see him in the closing. But it says Associate Justice Wilson clearly Associate Justice Wilson clearly states that the highest intent and property is the right to dispose of a thing. This is a thing that the instant petitioner lost without procedural due process and any compensation. All right. Let's review this again. Let's go back up to the top. Analysis provided herein are the reason for granting the writ or simultaneously both argued by the original intent of the framers of the United States Constitution and living Constitution case law analysis. All right, that's what we're trying to review. All right, or trying to get the courts to see in light of our remedy. All right, because we need a remedy. All right. So it's the analysis which must be done provided herein are the reason for granting the writ or i.e. a court warranto, because a court warranto is a writ as well, all right? Or simultaneously both argued by the original intent of the framers of the United States Constitution and the living Constitution case law analysis. Associate Justice of the Supreme Court of the United States, James Wilson, who left Scotland during the high land clearances, was particularly focused on the fee simple absolute and real property as favored through Queen Imperatrix of Edward I in 1290. All right, this right did not belong to him. Associate Justice Wilson, being one of the only 6 signers of the votes of the 1776 United States Declaration of Independence, and as the framer of 1787 of the United States Constitution, conducted a public discourse upon jurisprudential and political science containing therein lectures as professor of law, at which time he published on the history of property, pages 85 to 11, whatever that means, APP application. In the first paragraph, Associate Justice Wilson defines the bundle of rights and property. Property is the right of lawful power which a person has to a thing. Of this right, there are 3 different degrees. The lowest degree of this right is the right merely to possess a thing. The next degree is the right The next degree of this right is a right to possess and to use a thing. The next and the highest degree of this right is a right to possess, not just the right to possess it, but to use it, and the right to dispose of a thing. All right? We see that. Associate Justice Wilson clearly states that the highest intent in property is the right to dispose of a thing. This is the thing that the instant petitioner lost without procedural due process and any compensation, taken, if you will, from petitioner for 30 years by Respondents Ordinances 11.16. Said Respondents Ordinance takes the right to alienate as fee simple absolute and reduce the petitioner's title to a feudal tenure until Thursday, October 4th, 2046 AD. The feudal tenure is if the local government wishes the petitioner or anyone holding latter feudal tenure must surrender possession. In effect, the potential sovereign right of personally owned private real property is usurped by the respondents' ordinance 11.16 to the local government. Associate Justice opinion in Chittum versus Georgia. That the original intent of the sovereign right of the citizenry limited, blanket, and complete delegation of personally owned real property rights to the federal or the state government. See Title 46, and he used the statutes that are not reserved for the state's government. It's reserved for the government of the religious incorporation of the corporation soul, all right, as established for the true ownership of the property, which represented by what we call the crown. Likewise, in Associate Justice Wilson Public Discourse and the Jurisprudence in the Political Science containing therein lectures as Professor of Law, which states that the sovereign right of private property is usurped in the proprietary signatory system. The proprietary signatory system is the initial step to the feudal system, which functions in part immediately prior to the Declaration of Independence. Did you hear that? The proprietary signatory system is the initial step to a feudal system, i.e., so it was abandoned in 1660 and then it was reinstituted by the proprietary signatory immediately prior to the Declaration of Independence. Through the revolution of the 13 American colonies, the proprietary signatory system, aka feudal system, ran in a direct parallel conflict with the allodial system of tenures and the Saxon law of original property. Did you hear that? Did y'all hear that? I'm going to say it again. The proprietary signatory system is the initial step to a feudal system which functions in part immediately prior to the Declaration of Independence. Through the revolution of the 13 American colonies, the proprietary signatory system, aka feudal system, ran in direct parallel conflict with the allodial system of tenures and the Saxon law of real property as established in the Law Review Commission right here. What is that? Before I close. Right here. Is that here? Yeah, right here. All right, right here. Property. Title 46. The section contains streamlined and consolidated language from the sources section as follows. It's taken from 46.3-1, it's taken from 46.3-5, it's taken from 46.3-14, and from 46.3-4, which states the rules against perpetuities, and it's taken from 46.3-9. The phrase fee simple has been used to indicate ordinary title to real estate, has been substituted for free in common soakage, a phrase used in some of the source statutes. The phrase has a number of meanings, but in this case is identical to fee simple. Fee simple is also intended as the equivalent to allodial, a word used in some of the older cases as meaning a form of ownership not subject to any rent, services, or acknowledgement to a superior. So as we see in the case law, he clearly says that the proprietary signatory system is the initial step to a feudal system which functions in part immediately prior to the Declaration of Independence. So prior to the Declaration of Independence, they're saying that the feudal system started to get underway. Through the revolution of the 13 American colonies, the proprietary signatory system, aka feudal system, ran in direct parallel conflict with the allodial system of tenures and the Saxon law of real property. He knew this, but when he tried to bring this attention to the Supreme Court of the United States, they're not trying to hear that. Why? Because you are not Anglo-Saxon. All right? You can't use the words of James Wilson because he was not Anglo-Saxon. Where is he at? James Wilson was a Scottish-born American founding father, legal scholar, jurist, and statesman who served as Associate Justice for the United States Supreme Court from 1789 to 1798. All right, so you've seen him, and a lawyer used him as a pawn to be able to extract rights that does not belong to him because he doesn't understand the proper right to conveyance of land that was actually designed for the customary or the ceremonial processes that were set up through what we call Livery of seisin. All right, which goes back to the descendants of King Alfred the Great, which is known as Athelstan, which means noble stone. Okay, so all those who are talking about this Rex 84, you have no clue about what you are talking about. Make sure I cover everything. So in closing, I'm here to restore that which was taken, which was a violation of the laws that were put in place to protect our lost estate when it was being used by foreigners that were allowed to come here by way of immigration under the Stuarts monarchy to what we call a republic now, which descended from a commonwealth, which resulted as a result of that which took place under the statute of Quintin Pretorius as a result of the conflict between the families of the Yorks and the Lancasters. All right? And we know that the statute of uses, which was created by Henry VIII, said that the uses were abandoned and they were supposed to be possessed by way of seisin to the beneficiaries. All right? So there is no more cess 2K use. It's a cess 2K beneficiary use for the beneficiary of the actual estate, which is only can be an intel heir. All right. So with that, I love you all. Once again, I go to court on April 16th, which is the actual day the proclamation from Parliament was enacted in lieu of the statute of frauds, which the state of New Jersey is clearly in violation of. Okay. So our estate is about to return back to us in whole. So all those who claim to have an interest in this estate, it ain't an equitable interest, all right? And if you do have an equitable interest, then we invite you to our platform, or you can invite us to your platform, and whatever who has the better claim in regards to the estate, under the authority of the state in which it was created, so be it. Because we know Atherton was our descendant. He was an Anglo-Saxon burgher, all right? And we are Anglo-Saxons because we have our authority filed for the records and the county register in regards to the conveyance back on the library of seisin, because we know on the library of law, our ancestors' problem with this by way of telling it and telling us that the estate was left from you. We didn't even see it in our sites. We did not just see it in our sites, but the territory extent that we didn't see within our sight as a result of our ignorance. All right, but now we see it. Now we see the vast estate within our sites, and we are allowed to possess it through library of seisin. All right, if you have such a estate, and that can only be done through your firstborn. But your firstborn must connect back to the proper way of the conveyance of the state, which started, as we know, through the statues of what we call Queen of Pretorius, all right, under Edward the First, all right. So if you can connect to that noble house or pedigree, then you are in world of trouble. That includes those who are listening to me, those who are officers, those who wish to be officers, those who are members, those who are not members, those who are stuck in limbo. You need to make your mind up quickly, because April 16th is next month. Okay? It all returns to me next month. All right? You can believe it or not. But the law is the law of the land. And I represent that law. And with that, we had the Third Temple English Church of England under the auspices of King Edward the Peaceful, which is the incorporation, personification, or impersonating of that noble King, King of Peace, Jesus Christ, which I am the incarnation of. All right? So in lieu of all the martyrs and saints, as prescribed through Article 4 of our Articles of Incorporation, we love you, we grieve you, and we honor you in lieu of this lecture. And with that,